final disposal, LCR I think is not let me verify. LCR not let me 215 notes so that I can substitute. First time it has come in after.
215 में already a case fixed. आप देखिए LCR देखिए अभी टाइम है. दे दीजिए मुझे LCR.
From supplementary list for final disposal item 1, second appeal 209 of 2018.
This case was admitted. No, notices were issued.
So you are
No, the respondent has not appeared, no.
No, it does not come for orders.
Sorry, notes?
It does not come for orders.
No, it has not come for orders. Your Lordship admitted the matter and issued notice. And on the same order, Your Lordship has fixed for final disposal.
SR, अच्छा. Notice is not served.
Yes, boss. Service report is awaiting. This order से admit हुआ था उसमें?
Just a moment. Respondent number is personally served. Respondent number 225 through respondent number 1 joint is shown. Notice is served. 5 respondent है?
हाँ, 5. But ये जो इसका प्रोसेस सर्वर का रिपोर्ट, respondent number 1 personally served, respondent number 225 through jointness
Shown.
and neither undelivered registered
इससे क्या मतलब registered cover से क्या मतलब?
No, ठीक है. तो
Process server का जब note आ गया, the notice has been served.
So your Lordship may accept it as valid, if your Lordship may fit it proper,
Record
and your Lordship may keep it for some other day because I was under impression the notice service नहीं हुआ है, appearance किसी का है.
ऐसा impression में मत रहा.
और वकालतनामा किसी का नहीं है. उसमें हम कल भी रात को स्टेटस देखे कि अगर किसी का वकालतनामा फाइल हो गया.
SA number 209 of 2018. As per the office note, notice upon respondent number 1 has been personally served and respondent number 2 through 5 has been served through respondent number 1 showing the jointness. Considering the office note, the notice is accepted as validly served. At this, counsel for the appellant has submitted that the matter may be posted on some other day so that he will prepare the case. The records has already been received from the concerned court. आज Thursday है, post on next Thursday for final discussion. Then next.
Item 3, first appeal 88 of 2024.
Next Thursday नहीं रखना. हो सकता है वो लोग किसी को engage
हाँ,
करें.
हो सकता है.
थोड़ा लंबा टाइम. आज
But next Thursday was that 6 होली के बाद notice.
एक बार रखते हैं 11 तारीख को, लेकिन करेंगे नहीं उसको. एक बार और देख देते हैं, ठीक है? On 11th under the heading for final disposal to enable the respondents to appear. आपको पहले ही बता दे रहे उस दिन.
हाँ.
Item 3.
आपको रिकॉर्ड देखना
हाँ, इसको आज के लिए खाली कर देते हैं. आज फर्स्ट डे है आफ्टर एडमिशन.
कहीं मैटर ऑफ राइट है क्या फर्स्ट डे?
फर्स्ट डे नहीं, LCR का वेरीफाई करते हैं, रिकॉर्ड चेक कर लेते हैं. आई एम रेडी टू आर्ग्यू नॉट ओनली लिमिटेड क्वेश्चन आवाज 14 को चैलेंज किया है जिसमें मेरा एक स्टोरेज का दिया गया है, एक स्टोरेज को छोड़ दिया.
इसीलिए तो आपका केस
हां, इसीलिए आज फाइनल डिस्पोजल में रखा है. खाली आवाज देख लेते हैं, इसको वेरीफाई कर लेते.
आप शुरू करेंगे, ऐसे हम टाइम नहीं देंगे.
नहीं,
वापस आपको शुरू करेंगे, हम आपको फर्दर हियरिंग के लिए टाइम. लेकिन शुरू आपको करना होगा.
शुरू आई एम रेडी.
चलिए यही मैटर.
यस.
आप हैं रिस्पोंडेंट?
State.
स्टेट.
State has only filed written statement in this case. but no evidence has been adduced on building. Lord, there are several exhibits showing.
The only point for determination is the
Second floor, first floor building.
आप
They have
सोच
given
लीजिए हम
only
ऑर्डर
for.
में लिखाएंगे उसके बाद उसके बाहर जाने नहीं
नहीं नहीं हमारा चैलेंज ही है लिमिट अवार्ड 14 का ही अवार्ड 14 इज चैलेंज ओनली
जस्ट
अवार्ड 7 पर कोई चैलेंज नहीं है लास्ट ऑर्डर शीट इज आल्सो देयर
लैंड एक्विजिशन केस नंबर 13 ऑफ 19 ठीक है अवार्ड 14 आप क्या बोल रहे हैं
award for there are two awards one with regard to the land another with regard to the building
Okay.
that award building Milord issue number 5 with regard to building they have given with regard to only ground floor first floor building Milord it has been proved that there is a first floor structure is also
just a minute. Issue number 5
yes
correct just a minute.
it has been decided in para 12
Enhanced compensations
yes
whether the petitioner is entitled to get enhanced compensation amount or not.
yes enhanced compensation amount with regard to land they have given enhanced with regard to
Finding
the
देखते हैं
yes this is the finding not in the same paragraph
सुनिए आपकी तरह स्पीड हमको नहीं है दूसरा जगह पे करने जाना है इतना तेजी से नहीं सोच सकते हैं ठीक है स्लो है दिमाग कम काम करता है मेरा
sorry Milord
इतना तेजी से नहीं, आराम से क्योंकि हमको पॉइंट ऑफ डिटर्मिनेशन फ्रेम करके हमें जरूरत है हाँ बताइए पैरा नंबर
12
पढ़िए जरा
from the above issues as discussed above it has come clearly that the said land and building are suited for commercial purpose and exhibit 7 the valuation chart of the building as well as the land of ward number 8 of Devghar for 2017-18 also shows that as per the valuation chart the rate of land is 28,74,800 so and so per acre. In this case, award number 7, it is admitted case that the land of objector of 0.878 decimal was acquired. So, according to the market value of the valuation of the land of award number 7 would be 28 into such and such 25 lakhs. Hence, I find that the compensation was not prepared by the land acquisition officer Devghar according to law.
So now it is enhanced.
This I am not.
No grievance.
No grievance.
आगे पढ़िए.
Since it has come in the cross-examination of petitioner objector PW1 Ravindra Kumar Rai that no map of preparing any building has been passed by the municipality. Hence, petitioners objectors are not entitled to gain compensation of deluxe building apartment. Rather, they are entitled at the rate of building with RCC roof. Exhibit 7 shows that the value of building of RCC roof is 3,051 per square feet and acquired is 382.5 square feet. So the valuation of acquired building comes so and so, such and such, and the building of related to award number 40. So the award of compensation as mentioned in award 14 is according to Act and side note.
Hence, I find that the objector are entitled to get the enhanced amount of compensation.
And also with regard to only one floor, that is our main. They have given only
So
of
earlier they had not given for anything.
anything. They RCC. Now they have given for first ground floor. That top we have exhibited the photographs of the buildings and other.
And it is not in dispute that there is a second floor.
There is a first floor that is not in dispute. They have
There is
said
first floor.
they yes, first floor is there. That is the one.
आपने जो यहाँ पे ये लिखा है इस अवार्ड में आपने जो अवार्ड में लिखा कि सैंक्शन नहीं है बिल्डिंग का that is why he is not getting the valuation for the first floor. Ground floor का सैंक्शन है
According to plots of findings, but there is no sanction map.
इससे क्या होगा बिल्डिंग ऑन द स्पॉट एग्जिस्ट कर रहा है ना फिर तब तो आप लोग ये भी डिसाइड करेंगे कहाँ डेविएशन है जिसका डेविएशन होगा बोलेंगे नहीं नहीं देंगे इतना ही देंगे फिर आप माप ही करिएगा दिस इज बियॉन्ड योर जुरिस्डिक्शन बताइए समझ गए ना क्या बात है सैंक्शन नहीं है तो पूरे बिल्डिंग का नहीं है कुछ भी नहीं देना था 0. Correct?
Moreover, that not the Kanyani lots is with CBI.
बाकी से कोई उनको मतलब ही नहीं है. You are not in appeal. Have you filed appeal? You don't bother about it. अभी तो पोजेशन पर भी कॉम्पनसेशन मिल रहा है, irrespective of टाइटल. टाइटल डिस्प्यूट भी डिसाइड नहीं होता है कॉम्पनसेशन, है ना. पोजेशन अगर मान लीजिए किसी का 50 साल से प्रूव हो जाता है, you have your circulars. समझ गए क्या है ये? आपने क्वांटिफाई किया है अपने फर्स्ट फ्लोर का कॉम्पनसेशन अमाउंट?
Same amount, 3,800 into this,
ऐसा
double will be
ऐसा
double.
हो सकता है ना. फर्स्ट अपील में हम लोग को क्वांटिफाई भी करना पड़ता है कॉम्पनसेशन. तो आप
I mean-
अपना क्वांटिफिकेशन तैयार करके
Yes.
और कब रख देंगे? सुन लिया अब हम, बताइए
Yes, that is the only issue that happens.
कब.
Mistake पर पूछ
किससे पूछेंगे? विद्वान अधिवक्ता सिर्फ लॉ से पूछ सकते हैं या फिर कोई जजमेंट दिखेगा. नहीं तो नया जजमेंट लीजिए. ऐसा थोड़ी है कि किसी पॉइंट में जजमेंट नहीं होगा तो कोर्ट से जजमेंट नहीं होगा. करेंगे फिर आप लोग अपना उसको सुप्रीम कोर्ट से सेटल करवाइए. कोई रीजन है?
But not there is admitted position that there is no sanction.
हाँ, यस, एडमिटेड पोजीशन. एडमिटेड पोजीशन ग्राउंड फ्लोर पे. ग्राउंड फ्लोर का क्यों दिए? वो भी तो एडमिटेड पोजीशन है, कि सैंक्शन नहीं है बिल्कुल. सिर्फ फर्स्ट फ्लोर का सैंक्शन है, वो भी देख लीजिए. दोनों का सैंक्शन नहीं है कि क्या?
दोनों कोई सेंस नहीं.
कोई सैंक्शन है ही नहीं.
Lots as per act. Notification lots is out of the.
आप देखिए रिकॉर्ड के बाहर तो हम आपका एक भी कुछ सुनेंगे नहीं. ये रिकॉर्ड है, इतना आया हुआ रिकॉर्ड, चेक कर लीजिए. ठीक है, रख देते हैं मंडे को. मंडे को कितना बांटेंगे बताइए. डिसाइड तो अभी कर देते हैं, लेकिन अब इनको टाइम चाहिए. इनको आज ऑर्डर नहीं चाहिए. कितना? एक केस है ना, 2:15 बजे मंडे.
Yes.
बस इधर उधर मत
I
जाइए.
can verify it on Saturday. The record I will
आपका
verify.
रिकॉर्ड
खाली
कोर्ट
record
में
Saturday
रहेगा.
Saturday
आपको
को
जब
verify.
हो 2-3 आप लोग को काम करना है. साथ बैठ जाइएगा भाई. कोई मतलब लैंड एक्विजिशन में कोई एडवर्सरी लिटिगेशन थोड़ी होता है. जो कॉम्पनसेशन पेबल है सो देना है आपको. ठीक है, साथ में बैठ जाएंगे. हमको कंप्यूटेशन भी चाहिए
I will
क्योंकि
try.
फर्स्ट एपेलेट
Yes.
कोर्ट को कंप्यूट भी करना. तो कितना एरिया है आपका,
Yes.
क्या है,
Yes.
ठीक है.
That I
पूरा
will-
फर्स्ट फ्लोर कंस्ट्रक्टेड है आपका. लिखिए फर्स्ट अपील नंबर 88 of 2024. Heard the learned counsel appearing on behalf of the parties. The
Yes, only one request. Lots सिर्फ Tuesday को.
ट्यूसडे को कितना केसेस? नहीं हो पाएगा. मंडे को करें.
बाहर
अब तो कुंभ खत्म हो गया.
नहीं जाना.
अब कहाँ है? बाहर वकील सब बाहर नहीं जाते कोर्ट खुला.
दिल्ली में केस लगा.
कहाँ लगा हुआ?
PCR
प्लीज तो प्लीज ऐसा मत कीजिए. वहाँ ऑनलाइन ज्वाइन करें. अच्छा ठीक है. कब तक? वेडनेसडे को.
yes much of this.
वेडनेसडे को. वेडनेसडे को फर्स्ट केस करेंगे.
Yes.
ठीक है. ये एडजमेंट आपकी सच बोलने के लिए कि आपने सुप्रीम कोर्ट का नाम लिया. अगर उनका नाम लेते तो हमारे पास कोई ऑप्शन नहीं था एडजमेंट करने के अलावा. The learned counsel for the parties are present. The learned counsel for the appellant has referred to paragraph 12 of the included judgment and has submitted that enhanced amount so far as the valuation of land is concerned has already been granted, in connection with which the appellant has no grievance. Thus, only grievance of the appellant is that no compensation has been awarded with respect to the construction in the first floor, which is on the sole ground that the sanctioned map was not available. He submits that the fact that there was construction on the first floor is not in dispute. He has submitted that the construction, that there was no sanction map by the municipality, but compensation for ground floor has been given. The Learned Counsel has submitted that the challenge in this appeal is relating to award number 14 and to the aforesaid extent. Counsel for the respondent has submitted that he shall examine the matter and also go through the records, and the matter may be posted for further hearing on Wednesday. Considering the aforesaid submissions of the Learned Counsel for the appellant, it appears that the sole point for determination in the present appeal would be as to whether the learned court was as to whether the appellant is entitled for compensation so far as the construction on the first floor is concerned, and what would be the quantum of such compensations, if any. Pose this case for further hearing on next Wednesday in the supplementary and to be taken up at 2:15 as the first case. The Learned Courtmaster is directed to retain the records of this case in the courtroom so that the counsels may go through the records.
Yes.
हमको कंप्यूटेशन अच्छे से बना के देंगे,
Yes, yes.
दोनों जने साथ मिलकर
Yes.
हम लिखाएंगे, दोनों ने मिलकर दिया है हमको, नहीं
खाली डबल हो जाएगा और कुछ नहीं होना है। ग्राउंड फ्लोर का फर्स्ट फ्लोर इक्विवेलेंट है। Yes, then I will
लिखना
calculate
पड़ेगा ना,
it.
रिकॉर्ड ऐसे नहीं हो सकता।
Yes, then from the record I will.
चलिए फ्लैग कर सकते हैं आप लोग रिकॉर्ड।
Yes.
सप्लीमेंट्री में करते हैं।
For orders with effect, item 4, first appeal filing number 7842 of 2024.
This is funded on defect. Defect number 22 surplus. Respondent number 35
There was a preemptory order for removal of defects. Then
Pursuant to that, I have filed an application. It is I number 401 of the What has happened in this case? This is a partition suit has been dismissed.
no, the preemptory order has taken its effect.
No, I have, in the meantime, I have filed an application for this.
No, after the expiry of the preemptory order, not expired,
No, it is not within the expiry.
not yet expired.
No. I have filed an application within the preemptory time.
No, but still you never mentioned it.
Today it has come to the board.
It can't be like this. If the preemptory order takes its effect,
No, question your lordship may kindly understand. Preemptory order, your lordship, my lord has passed preemptory order. If I do not take any steps, then it will be dismissed, not otherwise.
have you filed any petition for
already
ignoring
filed an
any
application.
defect?
I have already filed.
Application for?
It is an application for the exemption of substituting legal representative of Mohammad Amidar Khan, dependent number 2 of that page.
You have filed an IPA for ignoring certain defects. 10289 of 24.
I have filed that application is also on board. I had argued that application. Thereafter, bench was of view, either you get it corrected from this decree from the civil court, or you file appropriate application. So I have filed an appropriate application.
It is not reflecting from the order sheet.
No, The law is very clear. If I did not, I fail to take any steps, then other, not in this case, other cases also. Otherwise, it would have been dismissed for default. There is no occasion. There is no occasion for coming to
It
today.
should have been dismissed for default.
No, it not at all.
You see, in those cases, they are not only, this is not the only case. In those cases
But,
where there is a preemptive time,
but,
and if anybody files an application for ignoring any defect,
but.
suppose
But
there is a,
it is not for ignoring. I have filed an application.
but there is a petition for ignoring any defect also. Should I dismiss it?
That petition will assume a kindly.
IA number 10289 of 24.
No, I have filed IA number 50.
So this I should dismiss it.
Well,
This I should dismiss 10289 of 24.
your lordship may dismiss. If your lordship is not satisfied,
No, there is no question of satisfaction.
your lordship may kindly approach. What is for a moment? My lord, what is the defect, your lordship? That respondent number 2, the name of the respondent number 2 is appearing in the deed. My lord, she died way back, my lord, in the 2010 itself. My lord, there is a provision under 96, Rule 96 of the, my lord,
Died in 2000.
10. Summons were issued to her. She did not appear, neither file a written statement.
In the trial, before the institution of that suit,
No, after institution.
during pendency of the suit.
During the pendency of the suit, she died, and despite service of summon, she did not appear in the my lord, the suit, neither file any written statement, and my lord, and because my lord, the respondent did not my lord, file any application under order 10A, then my lord, or any information with regard to her death. My lord, the learned trial court dismissed the suit. The name of her name is appearing as a respondent.
Her name is still there as a respondent, and it was not brought to the notice of the trial court that she has expired.
Yes. Now the question, your lordship.
From where do we gather that she has expired?
My lord,
From where do we gather that she has expired?
they have filed applications.
Who?
The respondents in connecting suit, where they informed that she died issued. But as per my instruction, she survives by certain legal aids. My lord, as per the law, my lord, I cannot impede a dead person. It is well settled. So, my lord, I file an application with my lord, a memo of appeal, arraying her legal aids as a party. And my lord, when the defect was pointed out, I file an application for ignoring that defect as per this, my lord, the Rule 96. My lord, there are provisions. My lord, that those can, if somebody want to be arrayed, those can be arrayed if the right to sue. Accordingly, I have filed that application. But the application was blessed. My lord, this honorable court, the predecessor's court, was of view that even if a person name is in the decree, it is a nullity. There are several judgments to that effect. My lord,
The decree is a nullity, or qua that person is a nullity?
actually, what I want to mean. At best, that can be what that person, it is a nullity. Whole decree will not go. And apart from
Particularly
that,
when the person did not participate and did not file any written statement.
yes, and particularly there is a provision that under that I have filed an application. Order 22, Rule 4.4, read with Rule 11.
I think that in such circumstances, we
Well-
call for the records firstly, because you say that it is already on record, and then we'll also issue notice before allowing this.
What I want to say is that, my lord, that petition I have already attended. Thereafter, what happened? Let me say. What happened? Thereafter, after that application, my lord, the conducting council have filed an application there in the court. That, my lord, against her name, ex-party may be mentioned. That ex-party has not been mentioned, but it is from the record, it is apparent that she did not participate, did not file a written statement. From the judgment itself, it will be appealing. Now the question is, merely because her name is appearing in the decree, will this first appeal will not be maintainable? That is what is the question. Or if the defect can be ignored, the matter can be admitted, that what is the point. So, my lord, I
So
have
through
brought-
this interlocutory application, you want certain more persons to be added as respondents?
No, I have already added. What I am finding that as per the provisions of Order 22 Rule 4, read with Rule 11 of the Report of Civil, my lord, as because she did not appear in the proceeding, and my lord, they did not file a written statement. So, my lord, the name which I have read her legal heirs agenda, I may be permitted to delete. And my lord, there is no need for any substitution, and because the law permits that if a person who files did not file a written statement, nor my lord appear in it, then my lord the court can exercise my lord this jurisdiction, and if this order is passed, then my lord there is no required for substitution. Your lordship may kindly see order
Therefore, we
22.
need to see the records, no? We'll call for the records.
Yes, my lord may admit it.
Not now. We will call for the records and then pass certain orders on the interlocutory application, and then only this case.
My lord, there are only two ways possible. First, your lordship, that my lord, on account of this, the whole degree should go, and the matter may be reported. But the question, your lordship, my lord has correctly my lord pointed out, whether it will be my lord against that defendant
So
only,
therefore-
or it will
So
go.
therefore, we want to see the records. What's the big deal about it?
No, your lordship may call for it.
We'll call for the records, and then we will pass appropriate orders on this interlocutory application. And then the case will be admitted or not admitted. And prior to admission also we can issue notice, because maybe that the court respondents may have to say something on this
That's
interlocutory.
what I am saying. Your lordship, I have several judgments to that effect. When a decree can be
That's
that
right.
is the first question I am asking, I am
That's right.
putting to Mark. If merely because the person's name in a decree, a dead person decree, even if the right to sue survives, then the decree does not get nullity. And a decree in a favor of a person. Suppose, my lord, we could not report the death of the plaintiff, and my lord passes a decree in the favor of the plaintiff. Whether that decree will be a nullity, there are judgments to that effect also.
It will not be a nullity.
That may be a nullity or may not be a nullity. It will be depending upon the facts of the case. Whether the decree is suitable or not suitable. Whether there is a possibility of two degrees or
Suppose a suit is itself dismissed. Suppose a suit is dismissed.
There is a question of suitability. Here in this case also, it is a partition suit. We are claiming certain share in the property, implementing her also as a party. Court has dismissed the suit. So there is no question of any suitability. The suitability questions will come only when the my lord will set aside this particular judgment and decree and will decree this.
And suppose you want that the suit should be decreed.
But
Then under such circumstances, it's a partition suit.
it is a partition suit.
Then under such circumstances, the legal heirs,
But-
if any,
but-
of the deceased defendant
But
will have a right.
they will have a right. Either and my lord,
They will have an independent right,
they will have an independent right. What
irrespective of the deceased,
What will happen
because
here?
they must be governed by Hindu law.
what will happen, Your Lordship? That my lord, they may question the decree that they were not a party. They may question, but the question, Your Lordship, when despite valid summon, if a party does not appear, neither file a written statement, nor my lord to take any steps, then in such a situation, my lord, if the order 22 rule for a petition is filed, the court can exempt from substituting the legal. That is one of the reports.
You see, in a case of partition suit, there is no question of exemption if there are major children of that particular person.
Yes, that is what.
Because their right is important, irrespective of the fact that that particular person has chosen to appear or not appear or may have died.
My lord, in that view of the matter, that is what there is a provision for Rule 96. Lord, that is what.
Rule 96 is after the decree, after the judgment and decree, isn't it?
No, it is prior. Your Lordship may kindly.
No, we will just a moment. FA number 7842 of 2024. Considering the nature of relief sought for through the interlocutory application number 401 of 2025, this court is of the view that the records of the case are required to be perused office is directed to call for the records of
Original partition suit.
original, sorry, in party title within bracket P, bracket close suit number 87 of 2005, decided by the learned trial court, white judgment dated 14th of May 2024. ट्रायल कोर्ट का नाम है सिविल जज विद इन ब्रैकेट सीनियर डिवीजन ब्रैकेट क्लोज -1 दुमका. लेट दिस ऑर्डर बी कम्युनिकेटेड. आने दीजिए रिकॉर्ड, इसके रिकॉर्ड बिना देखे ऑर्डर
There is only two.
the record should include all the miscellaneous petitions filed in the suit.
There is only two ways. First, you will assume that taking into consideration smaller ends of justice, etc., then their heirs should be made as a party. It is what is my view also. That is for that only I have filed that.
We'll see that.
And if Malad, they are, on second view is you will assume my submission. Then I may be exempted. It is only two. Otherwise, what will happen? That suppose this decree will go, then the matter will be remitted. These plaintiffs will get an opportunity, a fresh opportunity of hearing for nothing.
There is no unity of title as declared by
As
the
per
National
us,
Trial Court.
unity of title and possession. That is the reason why seeking partition.
That's
The court
We'll
has-
see. We'll
Yeah.
see. Let the records come. It's a technical issue, and we
This
need
is a
to-
technical issue.
It's a technical issue. Therefore, we have to be very
And
careful.
I will give several judgments to that effect also.
एक लिस्ट दे देंगे आपको, दूसरे केस में भी लगता है एक लिस्ट हमको प्रोवाइड कर दीजिए.
This is the judgment of apex court also. That there are several judgments to that effect also. If one of a party dies merely because that, and if his other legal heirs are on record, then in such cases it will not be.
No, but if the other legal heirs are not on record,
There are also, this is a partition suit.
no.
Brother is on record.
No, brother might be on record, but the point is that if there is a co-partner, let's assume,
Yes.
if there is a
This is a
co-partner
matter of a
X,
Muslim.
that's right. Let us assume Hindu law for a moment. We understand it better because we are dealing more with Hindu
Yes.
laws
Yes.
than Mohammedan law. Suppose there is a co-partner.
Ma'am.
He has 4 major sons,
Ma'am.
and he has been made party only. 4 major sons are not party to the proceedings, and he dies during the pendency of the suit. Then those children who did not join in, who were not made to join, merely because their father has expired, have no right.
No,
They had the right. They had the right by virtue of their majority itself.
Yes, I agree to that proposition. But there are certain other issues involved that I am not on that. Right?
We'll see. We'll
But
examine
this is
it.
one judgment also. In this particular case, Malad, in one of my case, in one of my case, this issue was raised that because some of the persons had died, so let it be dismissed as not mental. Then Malad, coordinate bench of this court also, after discussing so many judgments and the judgment which was relied by the predecessor's court also, it came to a finding, no, in all cases, this proposition will not apply. It will depend upon the facts and circumstances. It will depend upon the facts and circumstances.
We'll see.
Yes.
This judgment has become final.
No, it is still pending.
Oh, it is interlocutory application.
It is an later on they had filed an application that was allowed.
Okay. हाँ, एक तो डेट देते हैं इसमें. 27th March.
Yeah.
Item 5, first appeal filing number 8769 of 2024.
Second half we have number of cases.
When IE we are filing, there's a preemptory order means if it is not removed by tomorrow, the third it is posted. So then it needs to be one IE we are filing this
आइए for
for limitation means 15 days. So it is being filed today only means that second half is 4:15 p.m. also it can.
ये तो आपके मेंशन करने पे आया है।
Yes, notes where after we have mentioned notes, we found that the IA which is on record, that is for the substitution petition, and one IA has to be filed in the main petition also. So that was left. So we have filed that.
In pursuance of order dated 20, IA number has been filed for removing the defects.
Yes, please. So those that is relating to 25(3) notes, that is relating to substitution, because these persons were not party of
IA number 2118.
Yes, please. And one IA has been filed for imitation in the substitution petition. And once the officers pointed out that there is one IA to be filed in the main petition.
बिना फाइल किए क्यों मेंशन करते हैं?
बस एक
नहीं करना
IA था
चाहिए।
रिकॉर्ड पे हम लोग को
तो
लगा
आप एज्यूम ऐसे एज्यूम करके तो बहुत दिक्कत है ना।
प्रीएम्प्टरी ऑर्डर है, इसलिए भी
प्रीएम्प्टिव ऑर्डर है तो मेंशन कर देंगे और जब केस टेकअप होगा तब बोलेंगे अभी आइए फाइल होगा। सही है?
It was in the file, yours it was not filed. Second half was
आइए सर।
For hearing under order 41 rule 11. Item date second April 217 of 2020.
Substantial question involved in page. Page 5 you guys see whether the non-court will fail to interpret the documents, defendant correct prospective interpretation of the document, indeed formulated substantial question of law, whether the learned court below.
कहाँ पर है?
Page number 5 your lordship.
आप कौन है भाई? थोड़ा बताएंगे आप प्लेंटिफ हैं, डिपेंडेंट हैं?
I'm defendant your lordship. I am defendant. इसमें your lordship previously एक सूट फाइल हुआ था प्लेन में.
एक सेकेंड ऐसे जैसे ऐसे सवाल पूछे वैसे वैसे। You are the sole defendant?
No your lordship.
Two defendants. There were only two defendants?
Yes.
Suit was decreed?
Suit was decreed in favor of the petitioner your lordship. Concurrent
Just
finding.
persisting my lord.
Concurrent.
Forbids.
सुनिए ना उनको बोलो। अभी नए नए आए हैं उनको बोलो।
दोनों कोर्ट में था.
No, your lordship. What happened is previously a title
मिस्टर
suit.
सानी को दूसरा कोर्ट में जाना है, आप टाइम वेस्ट
नहीं हमको समझ कर.
इसमें previously title
Suit was decreed,
in favor of the.
appeal dismissed.
Yes.
Suit for what?
Suit for declaration of title your lordship.
Declaration of title.
Yes.
And
And injunction lordship.
an injunction. आपका सूट क्या बोल के डिसमिस हो गया?
इसमें मेरा सूट में योर लॉर्डशिप इससे बैकग्राउंड बताना जरूरी है. बैकग्राउंड बताना जरूरी है लॉर्डशिप. इससे पहले इसके फादर एक टाइटल सूट फाइल किए थे 1981. वो टाइटल में ये डिक्लेयर हो गया था कि जिस सेल डीड से ये परचेज किया लैंड वो नलिटी है, नल एंड वॉइड है. उसके बाद उसी के वेंडर इनको सेल कर दिए बाद में. अब वो एग्जीक्यूटेड डॉक्यूमेंट्स, लिस्ट ऑफ एग्जीक्यूटेड डॉक्यूमेंट्स में दिखा देते हैं. यही मेरा कहते कि ऑलरेडी वो जो पर्सन मतलब डॉक्यूमेंट सील डीड को इनको एग्जीक्यूट की वो ऑलरेडी मर गई थी 1958 में. फाइंडिंग ऑफ द कोर्ट है. और उसके बाद ये 74 में उस डीड मतलब वो छुपाते हुए उस फैक्ट को मतलब उसकी इसको डिग्री करा दी गई. अब वो एग्जीक्यूटेड डॉक्यूमेंट उनको इग्नोर कर दिया गया. वो फाइंडिंग
आपकी बात हमको समझ में नहीं है.
योर लॉर्डशिप
एक पहले सूट हुआ था बिटवीन द सेम पार्टीज.
यस.
टाइटल सूट का नंबर
टाइटल सूट नंबर 51 बिटवीन द पार्टीज नहीं था योर लॉर्डशिप. उसमें ये विटनेस थे लेकिन उसमें ये डीड को एग्जीक्यूट किया गया था ये दिखाने के लिए जो सुशीला बावरी है वो जीवित है जो डीड को एग्जीक्यूट की है इनको इनके वेंडर को. बट उस डीड में उस फाइंडिंग दिया गया कि वो ऑलरेडी मर गई 1958 में, इसलिए ये डीड नलिटी है. उसके बाद इसको छुपा के उसके वेंडर इनको बेसेल कर दिया. वो डीड एग्जीक्यूटेड है. एग्जीक्यूटेड दिखा देते लिस्ट ऑफ द पेज 24 में. page 24, para 6.
पहले उसके पहले आप हमको
बैकग्राउंड भी योर लॉर्डशिप,
हम सुन रहे हैं। ये जरा देखिए जो आपका इशू है ट्रायल कोर्ट का,
यस,
इसमें कौन सा इशू नंबर आपके लिए रेलेवेंट है?
ये योर लॉर्डशिप, इशू नंबर, ये मतलब इशू नंबर योर लॉर्डशिप 4, 5, 6, 7 ये रेलेवेंट है योर लॉर्डशिप, और
4, 5, 6 और
3 भी रेलेवेंट है, क्योंकि ये इस जो इनका इसमें है कि वेदर इशू नंबर 5, whether plaintiff has acquired right title interest possession on the strength of registered sale deed 7306 and 7307 dated 12/12/94।
इशू नंबर 5 हम लोग देखेंगे।
हाँ, और उसके बाद वेदर सुशीला, और सेकंड भी देख लेते हैं लॉर्डशिप, whether Susila Bauri was legally married wife of Sambhu Bauri and being legal successor of Sambhu Bauri, she rightly transferred his scheduled property to one Santosh Baladasi through valid registered sale deed 18307 dated 21/6/1974 and 25/234 dated 7/10/1974 and 53/238 dated 1/5.
Do you want to say that these sale deeds
Yes, declared.
were declared null and void?
Yes, judgment is also there.
In which suit?
In suit, your lordship. 51, टाइटल सूट 51, टाइटल सूट 51 ऑफ 1981। उसके बाद इस पे अपील फाइल हुआ, वो भी डिसमिस हुआ, सेकंड अपील हाई कोर्ट तक गया, वहां भी डिसमिस हो गया।
Stating that this Srimati Santosh Bala Dasi died in
नहीं, संतोष बाला नहीं, सुशीला बावरी died in 1958।
Shushila.
संतोष बालादासी सुशीला बावरी से कर दी।
Yes. ठीक, ओके। ये जो टाइटल सूट की बात कर रहे हैं,
Yes.
इसमें डिपेंड जो इसमें रेस्पोंडेंट्स हैं,
Yes.
दे वर पार्टी।
They were not the party, और ये तो खरीदे ही नहीं थे, वो जो इनको बेचे हैं वो उसमें गवाह थे।
गवाह थे कि पार्टी?
नहीं, वो उसमें गवाह थे और डीड एग्जिबिट किए थे। ये सुशीला बावरी के द्वारा सेल किया हुआ लैंड कोई
गवाहों पर भी बाइंडिंग हो जाएगा कोई फाइंडिंग?
यू नॉट सी वो डेड है, ये फ्रॉडुलेंट करके फ्रॉडुलेंट डीड को यहाँ पे एग्जीक्यूट किया, उस फाइंडिंग को छुपाते हुए, क्योंकि एक फाइंडिंग जो उस टाइटल सूट में उस समय का है वो कैसे इग्नोर हो जाएगा लॉर्डशिप, जो हाई कोर्ट तक वो फाइनल है। वो
कोई भी सूट में कुछ डिसीजन होता है, इट ओनली बाइंड्स द पार्टीज।
यस लॉर्डशिप,
डज इट बाइंड द विटनेस?
ये विटनेस को बाइंड नहीं करता, बट उसको नॉलेज था लॉर्डशिप, विटनेस था तो वो ही एग्जीक्यूट कराया वो डीड को, उसके वाइफ थी कि ये प्रूफ करने के लिए सुशीला बावरी जीवित है 1974 में, बट उसको एक कोर्ट बोला कि नहीं वो जीवित नहीं है, वो 1958 में मर गई, उसको सेट असाइड कर दिया, वो उसको नहीं माना गया। उसके बाद ये छुपा के वो 94 में फिर डीड कर दिए एक को,
छुपा के मतलब क्या?
मतलब
तो
उस
witness है, क्या छुपाएंगे?
उस समय वो टाइटल डिक्लेरेशन फाइल नहीं किए कि हमको इसको टाइटल दिया जाए, वो सेल कर दिए दूसरा को 94 में छुपा के इस फैक्ट को, क्योंकि वो हार जाते उस समय की वो डील नल एंड वॉइड हो जाता उस आधार पे।
तो इनका जो बेसिस ऑफ परचेज है,
यस,
दैट हैज बीन डिक्लेयर्ड नल एंड वॉइड।
यस, यस,
यही कहना
हाँ,
है?
फर्स्ट जो बेसिस है वो नल एंड
इनका वेंडर का जो टाइटल
हाँ,
है,
yes, yes,
दैट
yes.
हैज बीन डिक्लेयर्ड नल एंड वॉइड।
Yes, yes.
यही आप बोलना चाहते
यस,
हैं?
यस। लिस्ट ऑफ द एग्जीक्यूटेड डॉक्यूमेंट्स ऊपर देखो।
एक सेकंड। Void entitled suit number 51 of 1981.
यस,
89
89
1989. Okay.
इसमें
इनका इसको इस टाइटल सूट पे जजमेंट को एग्जिबिट कराया
यस, यस, पेज
कहाँ?
24, पेज 24
पेज 24
पैरा 6 में।
रनिंग पेज बोल रहे हैं?
यस, यस, पेज 24 ऑफ माय पिटीशन। नहीं, पेज
आप
पेज 24 ऑफ द
भाई इंटरनल पेज बताइए आपका,
Internal
4
page
पेज
6.
नंबरिंग।
6
6 हाँ बताइए।
पैरा मतलब 6 में देखा जाए एग्जिबिट बी
Exhibit B.
certified copy of the judgment passed.
ठीक है? अब आप हमको ये
Exhibit C.
बताइए,
हाँ.
Exhibit B,
हाँ,
ये तो टाइटल अपील छोड़ दीजिए, ये पूरा मतलब
सेकंड अपील था।
सेकेंड अपील और अल्टीमेटली फाइनल हो गया एग्जिबिट
yes,
बी।
yes,
एग्जिबिट बी सी ये सब का डिस्कशन ट्रायल कोर्ट के जजमेंट में कहाँ पर?
ये इम्पोर्टेंट।
बताइए, वेयर हैज इट बीन डिस्कस्ड?
उसको एक मैं योर लॉर्डशिप ये जजमेंट भी दिखा दे रहे ट्रायल में, ये देख लिया जाए इसमें जो एग्जिबिट था।
हम आपके पॉकेट से निकाला हुआ कोई डॉक्यूमेंट सेकेंड अपील में नहीं देखेंगे।
नहीं एग्जिबिटेड है इसलिए।
हाँ, तो इसको
पेज
चलिए।
9, इनर पेज 9।
इनर पेज 8 से ही शुरू हुआ।
हाँ, इससे शुरू हुआ उसी।
चलिए, यहाँ पे इनका केस इनका केस है, पैरा नंबर 9 में आपका केस है। यस काउंसिल, पैरा 9 में आपका केस है। इंटरनल पेज 7
यस,
और इसका डिस्कशन है देयरफॉर इट इज पैरा 9। पढ़िए, थोड़ा सा पढ़िए पैरा।
on the other hand, defendant's specific case is that after the death of Sambhu Bauri, Susila Bauri got remarried with one Banku Bauri of village Asara, district Bardwan, and she remained there, and she had got no concern whatever with the property of late Sambhu Bauri. So the question of execution of registered sale deed in favor of Santosh Baladasi does not arise at all. Moreover, the said Susila Bauri transferred the some land in Khata number 5, for which transfer title suit number 5189 was instituted by Suku Bauri and Lakhi Bauri. Again, the transferee of Biswanath Bauri and performer defendant Naru Bauri and Suki Bauri. Challenging the title of the said Susila Bauri for the land left by the Sambhu Bauri, which was decreed in favor of Suku Bauri, my father-in-law, and other white judgment decree 25/4/1992. By then, learned court, and it's been observed that Susila Bauri had got no right to transfer the land of the Sambhu Bauri after she remarried. As a result, entire land recorded in Khata number 5 had been inherited by the plaintiff Suku Bauri and others. Thereafter, the said Biswanath Bauri preferred title appeal number 3092, which has been dismissed on 25/7/2022 by the learned Assistant Session District Judge 3, Dhanbad, by confirming the judgment and the decree passed in the title suit 5189. Thereafter, the said Biswanath Bauri also preferred second appeal 198 of 2002 before the Honorable Jharkhand High Court Ranchi, which has been dismissed by the order dated 24/4/2004. Moreover, the proceeding had been initiated under section 144 of CRPC with regard to the suit land between the party, White MP case number 684/2000T. But the plaintiff has lost the said proceeding as deed transfer standing in the name of Santosh Baladasi, Vice Governor Dasi, nothing but a conclusive document, merely a paper transaction, and the same do not confer any right, title, interest over the suit land. Therefore, the plaintiff have no right to claim over the suit land by virtue of registered sale deed executed by Susila Bauri. Therefore, it is obvious that the judgment of
Okay, now we have got this.
Yes.
That in the title suit it was declared that Sushila Bauri had no right to transfer the property.
No, that is.
That is the finding.
I am the defendant, yours. If they are claiming this.
This is your case, no? That
it is.
ये आप ही का तो केस है, पैरा नंबर 9 में।
Yes.
आप डिफेंडेंट है ना?
Yes.
आपका कहना यह है कि in that suit it was declared that Sushila Bauri had no right to transfer the property.
ये तो वो लिखे और भी इसमें आया फाइंडिंग कि वो जीवित भी नहीं थी, वो भी आया है।
कम से कम इसको तो हम लोग समझ लें ना कि टाइटल सूट में ये
राइट वाले
डिसाइड
का
हो
प्रेस
गया।
नहीं कर रहे हैं हम, सब्सटेंशियल क्वेश्चन ऑफ हम ये
ऐसा नहीं होता है। जब यही डिसाइड हो गया कि शी हैड नो राइट टू ट्रांसफर द प्रॉपर्टी, वो जीवित थी कि नहीं थी इसका क्या रेलेवेंस है ना? When it was decided in the title suit that she had no right to transfer, how does that make a difference whether she was alive, not alive? It makes no difference,
नो
right? उसका फाइंडिंग क्या है इसमें? फाइंडिंग बताइए।
जजमेंट का ये बात पीसी के बाद
इसी यहाँ पे डिस्कशन है। Therefore, it is clear.
1994 का डीड है 2024 में डिक्लेरेशन फाइल कर, और वो 74 का डीड था, कितने इयर्स बाद ये फाइल कर रहे हैं। और वो जजमेंट यूनिवर्सिटी एक बार दिखाएंगे, एग्जिबिट है यूनिवर्सिटी, एक बार देखिए रिकॉर्ड पार्ट।
कौन सा डीड?
ये यूनिवर्सिटी एग्जिबिटेड है ये डॉक्यूमेंट्स, ये बस ये
एग्जिबिट नंबर है,
एग्जिबिट नंबर
एग्जिबिट नंबर
एग्जिबिट नंबर बी, यूनिवर्सिटी बी सी डी दोनों सब है। NCR required है।
आप जरा इंटरनल पेज 17 ऑफ appellate कोर्ट जजमेंट। It is crystal clear that neither Sushila Bauri nor her purchaser Santosh Baladasi or the plaintiff were party in the title suit number
ये तो
51 of
settle है,
19.
ये इशू ही नहीं है, ये सब्सटेंशियल क्वेश्चन ही नहीं है।
The suit land was also, तो क्या substantial question?
सब्सटेंशियल क्वेश्चन है कि यूनिवर्सिटी ये जजमेंट यूनिवर्सिटी
किसके ऊपर बाइंडिंग होगा?
बाइंडिंग ये फाइंडिंग है यूनिवर्सिटी की, उसका डेथ हो गया है।
नहीं फाइंडिंग क्या है? कोई वो
नहीं,
पब्लिक इंटरेस्ट लिटिगेशन है फाइंडिंग
नहीं
क्या है?
नहीं, इसके जो सेलर हैं वो जानते थे, उसमें एविडेंस है। देखिए गोवर्धन दास और
इससे
PW4
क्या मतलब है?
वही
कोई-
सेल किए
कोई
फ्रॉडुलेंट,
भी जजमेंट विटनेस पे बाइंडिंग होता है।
तो विटनेस ही प्रोड्यूस किए यूनिवर्सिटी, वो अपना डीड प्रोड्यूस किए, उसके बाद उनको पता चल गया कि ये डीड को माना नहीं गया, तो उसके बाद उनको डिक्लेरेशन उसी समय फाइल करना था, तो वो नहीं फाइल किए यूनिवर्सिटी। इसमें जजमेंट भी है यूनिवर्सिटी, जजमेंट
कहाँ लाए हैं जजमेंट?
दिखा नेक्स्ट वीक दिखा देंगे।
नेक्स्ट वीक नहीं लेके आइए जजमेंट, कल लेके आइए जजमेंट लेके आइए कि विटनेस के ऊपर
मैं
बाइंडिंग।
विटनेस के ऊपर बाइंडिंग नहीं बोल रहे, सब्सटेंशियल क्वेश्चन ये कि क्या फाइंडिंग ऑफ द कोर्ट को जो प्रीवियसली कोर्ट का जजमेंट है उसको सेट असाइड एकदम से कर दिया जाएगा, न्यू फाइंडिंग कर दिया जाएगा कंक्लूजन में, ये सब्सटेंशियल क्वेश्चन
लेके आइए आप जजमेंट, आपको दिखाना है। आप चूंकि एकदम जूनियर काउंसिल है इसलिए लेके आइए, आपको दिखाना। कैसे बाइंडिंग? यहाँ पे तो क्लियर कट यहाँ पे फाइंडिंग है, इट इज नॉट बाइंडिंग।
नहीं, बाइंडिंग पे हम नहीं बोल रहे, वो
फिर-
फाइंडिंग है कि वो उसका डेथ हो गया यूनिवर्सिटी,
किसी भी केस में किसी का फाइंडिंग हो जाएगा, डेथ है तो क्या बाइंडिंग हो
उनके
जाएगा?
नॉलेज भी तो था सेलर को लॉट,
इससे क्या मतलब है? नॉलेज से क्या लेना देना?
उसको बेच दिए फ्रॉडुलेंटली यूनिवर्सिटी, वो डीड को भी एग्जिबिट नहीं कराया 74 का, वो अपना 94 का डीड उसको हाइड करने के लिए, वो वेस्ट बंगाल का डीड है, इसीलिए वो फॉल्स डिग्रेड हुआ था उस केस में। उस डीड को तो एटलीस्ट प्लेंटिफ को एग्जिबिट करना चाहिए था।
आपका जो डीड है,
हाँ,
is it, has it got any relation with the earlier deed?
Both the courts concurrently held that Susila Pauri, the original owner, to whom they are disputing, she was neither a party to the suit, number one. Number two, neither the suit land which has been sold to us part of the land which has been purchased by us by our Exhibit 6 was a suit property in that suit. And therefore, the courts have also held that Susila Bauri, so far their contention is concerned, it has been negated, holding that she died in 1975. Prior to it, in 1974, she sold in some property which has been sold to us, that is to our vendor. And both the courts concurrently finding and discussed
The property was also different.
property was also not part of the suit, part of the
Earlier suit.
previous suit. So previous suit was between between the purchaser from Susila Bauri, like us. He purchased another property from Susila Bauri, and that deed, without including the seller Susila Bauri as a party defendant in this suit, previous suit, they got a decree.
That she was already dead.
Yes, that whatever it will be, it is behind her back. Susila was not a party. Susila was vendor of two persons. Number one, the defendant against whose said they have preferred the suit. So that defendant contested. Up to High Court, he lost.
So Sushila sold two properties.
Susila earlier.
Which one of the property was subject matter of the earlier suit.
Yes.
And the subsequent
Subsequent
property and
property-
another property is subject matter of the present suit.
Present suit. And
So
which was
whether-
not the part of this previous suit.
Which
Which
was
is
not
been
a part of.
concurrently held by both the courts. I will just refer only
Please.
one paragraph. You
Please.
Lordship just see the title. First of all, the trial court judgment.
Yes.
If Lordship may kindly come to the directly to that issue, Your Lordship may kindly come. Yes. Your Lordship just see page inner page 9. नीचे लिखा हुआ है 9.
Inner page 9.
Yes. Towards middle.
Yes.
Therefore, as Your
Just,
Lordship got
just,
it.
just
Village के बाद वार्ड शुरू हुआ village. Therefore,
एक second.
13-14 years जहाँ लिख रहा है CP केस
64, 65 दिख रहा है.
हाँ 546 by 95.
हाँ.
He further said in para such and such.
That's it. There.
Yes. Therefore, Susila Bauri was alive even after execution of registered sale deed in the year 1974 and 1975. He further this is submission. I'm just coming to the finding also. Submitted that it is admitted fact that Susila Bauri was wife of Sambhu Bauri. He further submitted that neither previous vendor Susila Bauri nor her purchaser Santosh Baladasi purchased in 75 was and 89 में लोग शूट किए was the plaintiffs nor the plaintiffs have been made party in title suit number 51 by 89. Moreover, the suit land was also not the subject matter of title suit number 51 by 89. Therefore, the judgment and decree passed in title suit 51 of 89 is not binding upon Susila Bauri or her purchaser or the plaintiff. Plaintiff or the subsequent purchaser. Susila Rasi through the registered sale deed of the year 1974 and 75 Exhibit 6. Moreover, it is finding of the Honorable Jharkhand High Court in second appeal that she has succeeded the property from her former deceased husband Sambhu Bauri in second appeal, which they are relying. Therefore, it is clear that Susila Bauri has got every right to transfer or alienate the property succeeded by her from her husband Sambhu Bauri. It is admitted fact, as stated above, Sambhu Bauri was none else but the son of survey recorded tenant Pago Bauri. Again, I am just skipping the evidence discussion. Ultimately, your Lordship may kindly see. The Honorable High Court has also decided the same in essay number such and such.
Just a moment.
Last but third sentence.
नहीं, moreover भी पढ़ी.
Moreover, वहाँ से पढ़
हाँ, moreover. Moreover, it is also evident
Yes. At page number 10.
at page 10.
Yes. Moreover, the suit land was also not.
नहीं, यहाँ से नहीं. Second line. Moreover, it is also.
Moreover, it is also evident that Susila Bauri or her purchaser Susila Baladasi were not. Dasi was not party to the title suit number 5189, which is admitted.
आगे पढ़ी.
Moreover, the suit land was also not subject matter of the said suit.
आगे.
From perusal of the judgment, it appears that it was not finding of the court that Susila Bauri died in the year 1958. Rather, the same is discussion of evidence on what
There is a finding there.
No finding.
There is a finding. बताइए अपना सब्सटेंशियल क्वेश्चन ऑफ लॉ। एडमिट करके सुनेंगे मिस्टर सानी, विल सी।
It's clearly a forged and fabricated document is in as of which the Susila already died in 1950.
कोई बात नहीं मिस्टर सानी, वी नीड टू हियर इट।
all seven all seven
आज तक 7 सब्सटेंशियल क्वेश्चन ऑफ लॉ हमने बनाए,
ठीक है।
बताइए।
तो सेकंड वाला बना दिया जाए नोट्स।
सेकंड वाला ना,
सेकंड थर्ड
Finding in absence of
जस्ट
the
वी विल सी। फर्स्टली ये आप रोमन 2 देखिए, आपको मिला है?
नहीं,
इनको जो दिखाई,
he should supply.
जस्ट आप देखिए ना, सब्सटेंशियल
देख
क्वेश्चन
लेते हैं
ऑफ लॉ
बाद
में
में।
आपको क्या ही सुनना
बाद
है।
में वो दे देंगे।
ये रोमन 2 बनाते हैं एंड साथ में ये भी बनाते हैं whether the judgment of title suit number 51 of 1981 will have any bearing in this case, as they were not parties in that proceeding. We'll see that.
ये सारा बना दिया जाए। जो भी आप डिसाइड कर दीजिएगा नोट्स, जैसा एक को छोड़ के नोट्स 2 सेकंड और ताकि कुछ मिस ना हो जाए।
Let him serve a copy.
Yes,
Right now,
yes, sir. लिखिए।
subsequent.
Essay number 217 of 2020 for the learned counsel for the appellant. The learned counsel for the respondent has already appeared in this case. है ना? आप सारे respondents का? The respondents have already appeared in this case. The learned counsel for the appellant has submitted that Shushila Bauri had already expired as back as in the year 1958, and a finding to that effect has been arrived at in title suit number 51 of 1989. By deciding issue number Roman 6, Roman 7 and Roman 8 in the said title suit. He submits that the learned courts have not properly considered the judgment passed in title suit number 51 of 1989. The learned counsel has also submitted that the plaintiff in the present case was also deriving title through Sushila Bauri, who had executed the deed in the year 1974 in the present case.
What did
By
it
the vendor.
95?
95. He purchased from the vendor.
Susila sold it to my vendor.
Okay, Sushila Bauri sold the property to the vendor
Vendor.
of the plaintiff in the year 1975. He has produced a copy of the judgment passed in title suit number 51 of 1989 for perusal of this court at this stage. He has submitted that the second appeal be admitted. After hearing the learned counsel for the appellant and upon going through the impugned judgment, this second appeal is admitted for hearing on the following substantial question of law as to whether ये रोमन 2 कर दीजिएगा. रोमन 2, ठीक है, और एक और whether the proceedings in title suit number 51 of 1981
89.
81 लिखा हुआ है, इसको 89 कर दें.
89 होगा.
1989 has any bearing in the present case in as much as the plaintiffs
Or their vendors.
or their vendors were not party in
Including
the
Susila.
including Sushila Bauri
Yes.
3 और 6 को भी यूनिवर्सिटी
were not party in the title suit number 51 of 1989. Let the records be called for from the concerned court. The let this order be communicated to that. Since the respondents have already appeared, no notice.
only one 3 और 6 is important यूनिवर्सिटी oral evidence पे गए only 3 और 6
We'll see that.
okay
Any date has been fixed.
हाँ डेट तो फिक्स हो बताइए कौन सा डेट पोस्ट ऑन 26 मार्च
यूनिवर्सिटी थोड़ा
for final
रिकॉर्ड
discussion.
आने में टाइम लगेगा थोड़ा सा आगे अप्रैल में
आप एकदम चिंता मत करिए रिकॉर्ड आने में टाइम नहीं लगेगा आप तैयारी
So out of the court, you will say request like memo का.
दे देंगे
करिए पेरेंट्स दीजिए उनको लग
Item K for hearing second appeal 21 of 2022.
इसमें रिस्पोंडेंट लोग से बात करना फाइल में
कई कई दिन से इसी पे चल रहा है कि आपको वकालतनामा
It was admitted on the last date of notice is very issue, on 6th of February.
6 February it was admitted. आपको किसकी तरफ से वकालतनामा
ये रिस्पोंडेंट रामविलास स्वरूप
रिकॉर्ड आ गया तो आप क्यों नहीं फाइल किया क्यों नहीं फाइल किया
नोटिस तो उनको मिला है
वकालतनामा मिल गया है ना आपको
हाँ
हाँ तो फाइल करिए और बहस करिए किसकी तरफ से वकालतनामा मिला
Sole respondent.
सॉरी
तो फिर क्या है बहस करिए फिर क्यों सोच रहे हैं आप रिकॉर्ड आ गया है देखिए हम कोई भी अपील एडमिट करते हैं ना हम काफी सोच समझ के एडमिट करते हैं
एक टाइम मेरे फर्स्ट टाइम कोई भी डेट दे दिया
कल
कल
कोई भी डेट में तो कल ही नियरेस्ट
उसके बाद में होली के बाद
इतना नहीं पेशेंस है हम देखिए आपको एक चीज बता रहे हैं
इसमें
एडमिट करते
senior-
समय
senior-
अगर मेरे हाथ का एडमिट किया हुआ केस है अभी आप देखिए ना कितना सुन के केस एडमिट करते हैं ऐसे नहीं करते सेकंड अपील इस तरह से नहीं हम एडमिट कर सकते बहुत माइंड मेकअप करके हम एक सेकंड अपील एडमिट करते हैं ऐसा नहीं है कि कॉन्करेंट फाइंडिंग में नहीं एडमिट करते इट इज नॉट लाइक एकदम बहुत छोटा सा क्वेश्चन बना हुआ है इसमें तो कोई बात ही नहीं
ठीक है एक टाइम दे दिया
एक टाइम दे रहे हैं ना कल करिए
कल नेक्स्ट वीक के लिए तो
देखिए ऐसे नंबर 21 of 2022 counsel for the appellant is present records have already been received from the concerned court Mr. नाम बताइए
इंद्रशेखर गुप्ता
Mr. Indu Gupta submits that he has received wakalatnama on behalf of the sole respondent which he undertakes to file in the proceeding. He has submitted that the matter be posted next week so that he may
Copy-
prepare.
Copy will have it.
अब अभी
जी जी.
a copy of the memo of appeal be provided to the learning counsel for the respondent. Close this case. ये final disposal में है? Close this case for final disposal on next Tuesday. Okay, on 5th. 5 तारीख. 5 तारीख ठीक है. The learned court master is directed to retain the records so received for the perusal of the counsel for the parties. Okay, at 2:15. At 2:15 नहीं अभी रखना चाहिए क्योंकि आई डू नॉट नो बहुत सारे मैटर्स 2:15 में रहते हैं ना तो एक दो मैटर भी टेकअप होने में ज़्यादा नहीं है इसमें. आपका जो जूनियर है उसको बोलिएगा करना. ऐसे 2:15 नहीं रखते.
जी जी बच्चों अगर इनके समय
थोड़ा सा नोट्स बना लीजिए आप लोग दोनों.
जी जी
ठीक है. इस इशू पर एक आध केस डिसाइड भी किए हैं.
जी बच्चों
ये इस कोर्ट से भी डिसीजन हुआ हम खुद डिसाइड किए. थोड़ा देख लेंगे, आपको मिल जाएगा.
Item 11, second appeal 151 of 2022.
Yes, appellant. क्या हुआ? Yes. Who is your senior? Who is your senior? खाली टाइम लेना आता. He will come मतलब क्या? तो वो छोटा सा इशू है. Appellate court for the first time adverse possession का एक तो इशू बना दिया है. प्ली था adverse possession का ट्रायल कोर्ट में. आप तो फाइल पढ़ने को मना किए. फाइल का आपका? आपको फाइल नहीं देते हैं? अभी आने दीजिए, उनको बताते हैं. आपको फाइल दिए थे पढ़ने के लिए कि नहीं दिए? और अभी फाइल कहाँ है? अपने साथ लेके गए दूसरा कोर्ट में. सब्सटेंशियल क्वेश्चन ऑफ लॉ क्या है? आपको नहीं पूछ रहे, इनको पूछ रहे. आपको एक चीज बताएं, जिस दिन केस रहता है उसके एक दिन पहले आपको कभी फाइल नहीं मिलेगा पढ़ने के लिए. एक हफ्ता पहले पढ़िएगा तो फाइल मिलेगा, है ना, क्योंकि उस वक्त वो आपके सीनियर उस फाइल को नहीं पढ़ रहे होंगे. एक दिन पहले फाइल खोजिएगा तो आपको कहाँ से मिलेगा? चलिए पास ओवर करते हैं. उनको बुलाइए, थोड़ी देर रुकिए.
From Readiness of Panel Soul Item 4, second appeal 37 of 2021.
This case Lordship had filed an IA. On the last occasion, Lordship was pleased to direct us to file a proper substantial question of law, Lordship.
Yes, yes.
That we have already filed, Lordship, by way of an IA, Lordship. We have also served the copy. Question of law was not properly framed, Lordship, therefore.
ये आप पेज नंबर 4 में.
हाँ, Lordship. A, B, and C.
ठीक है. आपकी कोई जरूरत नहीं है ना क्वेश्चन ऑफ लॉ फ्रेम करने की.
हाँ, इनकी कोई जरूरत नहीं. Since it is already an admitted case there.
कोर्ट इज ऑलरेडी इन एडमिट.
Yes.
हाँ हाँ yes. हाँ बताइए.
उसी पॉइंट पे that is the only crux of the matter.
इनका जो मैटर है
इनको आपने कॉपी नहीं दिया है
नहीं,
सब्सटेंशियल.
हम तो सर्व किए.
सर्व किया हुआ है आपको. सर्व किया हुआ है आपको. अच्छा एक बात बताइए,
Lordship.
अगर आपका रोमन 2 में हम लोग देखें कि ऑर्डर 41 रूल 31 का प्रोसीजर फॉलो हुआ है कि नहीं हुआ, देन अंडर सच सर्कमस्टांसेस द मैटर हैज टू बी रिमांडेड बैक.
Yes, yes.
देयरफॉर वी नीड नॉट एंटर इनटू अदर.
Yes, Lordship can do that.
देन अगर रोमन 2 हम लोग देख लेते हैं तो दैट शुड बी.
Since Lordship, what I am submitting.
अच्छा एक और भी तो बन गया है ना, तो उसको भी तो आंसर करना ही होगा.
हाँ, even if not entering into the any other substantial question of law, if Lordship finds that the proper appreciation of Order 41, Rule 31 has not properly been done, only on that ground
Then
it
I'll
can be
keep
remanded.
all the matters
Yes.
open
And Lordship may say that other matters did not required to be answered.
At this
since,
stage.
at this stage, since the matter is being remanded for reconsideration of the
तो
matter.
आप ये ऑर्डर 41 रूल 31 वाला दिखा दीजिए हमको. ठीक है, काउंसिल रेस्पोंडेंट.
इसी में से हुजूर है, यही जो हमारा सब्सटेंशियल बना है ना, इसमें क्या हुआ है, हम जस्ट स्मॉल पॉइंट बता दे रहे हैं. The sale deed has not been properly been considered. Sale deed में 2 रामू रवानी है.
तो ये तो मेरिट का हो गया ना. ऑर्डर 41 रूल 31 का आप हमको कंप्लाइंस पॉइंट ऑफ डिटर्मिनेशन बना.
That is there, that is there. वो तो हुजूर the lordships has made the point. My actual point of law is this.
तो फिर ये जो आप लोग का ऑर्डर 41 रूल 31 में जो आप
That is a general thing has been.
without framing any specific
yes.
point in this appreciation, where is the point of
Yes,
determination?
Lordship.
But this next week, assist him.
कोई बात नहीं, आप पढ़िए इसको. नेक्स्ट वीक नहीं है.
What has happened in this
बताइए.
case?
हाँ बताइए कहाँ
Issue
है.
has already been decided in this, the plaintiffs are the party before the court below. So barred by the res judicata, the issue was decided earlier. In title suit number 12 or one title suit 7 of 1940.
Where is the point of determination?
It is not there. And therefore that issue is framed.
पैरा नंबर 15 देखिए. Main question is sale deed number 3043 dated 15/12/19.
Is a valid document or not?
Yes. ऐसा तो नहीं है ना कि कुछ भी नहीं है.
इसके बाद कुछ भी नहीं होती. ये this is the general question which has been framed. It is not a
General
point of
question थोड़ी है
determination.
ये. It is a very specific thing.
No, specific it is not there. Therefore, this point was communicated. Except para 15, nothing is there.
That's right. So legality and validity of sale deed number 3043 dated 15/12/1992 was the question to be decided.
Yes, yes.
Yes. और कितना specific होगा बताइए.
Therefore, Lordship, that question is required to be additional substantial question of law, because since they are alleging the sale deed to be not to be
पैरा नंबर 8 आप देखिए.
para 8 of the appellate portion. Yes, Lordship.
है ना 3 क्वेश्चन.
These are not. Lordship, yes, yes, yes. दो है.
है ना इसमें.
हाँ है.
तो ये तो नहीं बोल सकते ना कि
नहीं,
point
नहीं,
of
it is-
determination नहीं.
Yes, yes, yes. नहीं, नहीं, आप
Sorry, but I am not in this case. Sorry.
क्या serial number 4 है.
A and B तो दोनों सेम ही है ना.
हाँ, same है.
तो सिर्फ B रखा. A का क्या जरूरत है.
हाँ, एक का point of that is
वो
judgment
तो
is there.
आपका
Yes,
argument
yes.
है.
हाँ.
ठीक है. Understand?
And C will be there.
C क्या है.
Order 7, Rule 3 का compliance नहीं.
What is order?
The particulars of Lordship, the details of the property should properly be there in this schedule as well as the document, which are proved from the document Exhibit B. And one more thing is there, Lordship. They have filed a case. They have got a schedule. This is my schedule. It should correspond to the sale deed, which they are seeking for cancellation. Now they have not exhibited the sale deed. We have exhibited.
And it is not corresponding.
Does not correspond.
Essay number 37 of 2020. An interlocutory application being IA number 2115 of 2025 has been filed for framing additional substantial question of law. The learned or for reframing the substantial question of law. The learned counsel has submitted that the first substantial question of law as framed by order dated 6/11/2023 stands clarified further by the additional substantial question. आपको कुछ बोलना है? ये दो है, हाँ? Considering the, आपको कुछ बोलना है इसमें, कोई opposition है आपको इसमें? यही लिखा दें? इसका कोई मतलब नहीं है. The learned counsel appearing on behalf of the respondents has not raised any serious objection to the interlocutory application, nor any counter affidavit as such has been filed to this application. And considering the nature of relief sought for, considering the impugned judgments, this and the substantial question of law framed earlier, this appeal would be heard also on the aforesaid substantial question of law number B and C. अब बताइए, आज ही करेंगे, कर लीजिए. Are you disposed of? कब करना बताइए आप? कब करना है? एग्जीक्यूशन कोर्ट केस का स्टे है, इसीलिए इसको कर लीजिए आप नेक्स्ट वीक. Pose this case on 3rd of March. 3 तारीख? Yes, council. 5th को हम लोग रखे हुए हैं ऑलरेडी. 5th को कितना? 5th को नहीं. 3rd को रखें. On 3rd of March, under the heading of final disposal. The final disposal
Yes.
under the same heading. उनको बता देंगे सिर्फ दो ही, पहला वाला नहीं किया है. BNC.
Item 5, second bill 52 of 2022.
Notices were issued, it has been validly served, but nobody has appeared.
Okay. It was directed to be posted on 19th,
Yes.
right?
Last time this evening.
Now they have not appeared.
Yes.
Not yet.
Is it possible that it can be taken up at 2:15?
2:15 we have notices. Okay, you come in.
Wait.
If it is not taken up by any chance, please continue. There is a first appeal in continuation.
Then I'll argue that it's a very small matter.
Chalo, like.
Lordship, we kindly see the order dated 27/1/2025.
What is this IA?
IA was for order for stay. Order 39 rule 1. The Lordship said that will be decided.
Yes. Yes, let us see the substantial question. You
Paragraph.
just read para 2 also.
Learned counsel for the appellate has submitted that the case arises out of a suit for specific performance of contract dated 19/3/2008. He has further submitted that the learned trial court dismissed the suit entirely on the ground that the readiness and willingness and the financial position of the plaintiffs to pay balance consideration amount of rupees 1,80,000 could not be proved. He submits that the finding has been reversed by the learned first appellate court, and the learned first appellate court has failed to take into consideration that plaintiffs visibly failed in disclosing the source through which they would pay the balance amount of rupees 1,80,000. He has further referred to the substantial question number D as framed in the memo of appeal. After hearing the learned counsel for the appellant, the second appeal is admitted for hearing on the following substantial question of law: whether the learned first appellate court has committed a substantial error of law while reversing the decree of the learned trial court and failed to consider that readiness and willingness on part of the plaintiff was not proved, as the plaintiff failed to disclose the source through which they would pay the balance consideration amount of rupees 1,80,000.
So everything is about readiness and willingness.
Yes. If you Lordship, we kindly come to the findings of the learned.
Let us see the law to what extent. We'll come to that because it's a very short one.
Yes.
What is the law on this point regarding readiness and willingness?
Yes.
Is he supposed to disclose his source from where? What is the law regarding this?
There are two things. First, he has to show that he was always ready and willing to pay the amount.
Always ready,
yes.
right?
Secondly, he also has to show, he also has to disclose in the pleading, and along with that, he has to prove by way of evidence that he was in a financial position to pay the rest of the amount.
Provided his financial condition is disputed.
Yes. No, but that is a requirement of law. So otherwise, also under section 16C, he has to plead that readiness and willingness would include the disclosure of financial positions.
Pleading as well as proof both.
Yes. So I'm allowed minus if I
Just. Yes. Any particular judgment you are relying on?
Para 10 from the first judgment. It's a very recent judgment, 2024.
Yes, please.
Placing para 10. The law is well settled. The plaintiff is obliged not only to make specific statement and averments in the plaint, but is also obliged to adduce necessary oral and documentary evidence to show the availability of funds to make payment in terms of the contracting type. There is a fine distinction between readiness and willingness to perform the contract. Both the ingredients are necessary for the relief of specific performance. While readiness means the capacity of the plaintiff to perform the contract, which would include his financial position, willingness relates to the conduct of the plaintiff.
Para 13 also, kindly read it.
Yes.
The High Court in first appeal.
The High Court in first appeal upon application of evidence on record, both oral and documentary, has arrived at the conclusion that plaintiff has failed to establish that he is always ready and willing to perform this part of the contract. This being a finding of fact and cannot be termed as perverse, there is no good reason for us to interfere with the judgment.
Let us see the other judgment.
Second judgment is paragraph number 24.
Yes.
Section 16C of the Specific Relief Act 1963 bars the relief of specific performance of a contract in favor of a person.
Just 1 second.
2022 SCC Online SC 840.
Para 24.
24. Section 16C of the Specific Relief Act 1963 bars the relief of specific performance of a contract in favor of a person who fails to aver and prove his readiness and willingness to perform his part of the contract. In view of explanation 1 to section to clause C of section 16, it may not be essential for the plaintiff to actually tender money to the defendant or to deposit money in court, except when so directed by the court to prove readiness and willingness to perform the essential terms of the contract, which involves payment of money. However, explanation 2 says that plaintiff must aver performance or readiness and willingness to perform the contract according to its true construction. To aver and prove readiness and willingness to perform an obligation to pay money in terms of a contract, the plaintiff would have to make specific statements in the claim and adduce evidence to show availability of funds to make payment in terms of the contracting time. In other words, the plaintiff would have to plead that the plaintiff had sufficient funds or was in a position to raise funds in time to discharge his obligation under the contract. If the plaintiff does not have sufficient funds with him to discharge his obligation in terms of the contract, which requires payment of money, the plaintiff would have to specifically plead how the funds would be available to him. To cite an example, the plaintiff may aver and prove by adducing evidence an arrangement with a financer for disbursement of adequate funds for timely compliance with the terms and conditions of the contract involving payment of money.
Yes. So much onus is there on the plaintiff.
Yes. Now, if you lordship may kindly also see paragraph number 46.
46.
Yes, the same.
Yes, please.
It is settled law that for a relief of specific performance, the plaintiff has to prove that all along till the final decision of the suit, he was ready and willing to perform his part of the contract. It is the bounden duty of the plaintiff to prove his readiness and willingness by adducing evidence. The crucial facet has to be determined by considering all circumstances, including availability of funds, and mere statement or averment in plaint of readiness and willingness would not suffice.
This is para number 24, 25 and
46.
46. Correct. This third judgment, in this third judgment perhaps there was no issue framed on readiness.
Yes, and that is also on the point of escalation.
Point of?
Escalation. If substantial period has passed out, the court has to take into consideration the escalation of events.
Are you pleading that that is not the point here?
It was the substantial question of law was not.
Para 28 says that no issue regarding readiness and willingness was framed by the plaintiff.
The other two judgments in play.
Just a moment. You read para 29 on this document. Okay, now let us see the findings. There is an order of reversal. So,
If you also may kindly come to the appellate court's judgment first. Page number running page 38.
running page
38.
38.
Yes.
What is the point of determination? Para number 13.
30. Page 36. As to whether the plaintiffs are ready and willing to perform their part in accordance with the sale agreement, Exhibit 2, as it is alleged in the claim, and as to whether the sale
Only
agreement.
point of determination number 1.
Yes.
Para 38.
Page 31.
Yes, please.
Further, on close perusal of oral evidence of PW1 Mohammed Khurshid Alam, who admittedly is the plaintiff number 1, I find that in the examination in chief on affidavit at paragraphs 4, 6, 7 consistently showed his eagerness, readiness in paying balance amount of rupees 1,80,000 in favor of the defendant, but later invariably was found reluctant in executing registered city. During cross-examination in paragraphs 13, 15, 16, 17, 18, 24, 32 and 33, he categorically has clarified the source of income admitted the plaintiffs to be income tax payee who used to file GST and its return, and deposed to the effect that he used to run BD making business and paying income tax and GST return for that. On paragraph 17 and 18 of cross-examination, it would appear that their BD making business has been running in the name and style as Aftab BD. At paragraph 37, he denied the suggestive question put to the effect that his BD business is in his brand name Aftab BD has been seized and not functional. So this is also important. Therefore, on collecting reading of his examination in chief and cross-examination, I find that it has effectively been explained and clarified by him that within 3-4 months of sale agreement, the plaintiff had arranged the balance amount and are capable in fulfilling the sale agreement in accordance with its terms and conditions. As far as suggestive question put during cross-examination to PW1 is concerned, it was open to defendant to show that BD making business run in the name of Aftab BD was closed earlier. With this
So the readiness and willingness has to continue throughout.
Yes, throughout the terms of the year.
And this was his only source of income.
Yes, and this is also not valid matters. I show that because he's saying that he was filing GST return and income tax return, but these documents were never brought on record. First, secondly, there was no pleading to that effect. So any evidence without pleading is void.
He pleaded readiness and willingness.
He pleaded readiness and willingness, but in the plaint he did not plead the disclosure of fund, which
Source of fund
Yes.
or capacity.
yes, ma'am. With this,
Even that is required to be pleaded in the plaint.
yes, ma'am.
Because of that debt.
Yes, ma'am. Now, if you lordship may kindly see page number 16.
Page number
16, the trial code. Finding
16.
16.
Yes.
Sixth line from the bottom, in para 26.
Hmm.
In para 26 of cross-examination, this witness admits that the defendant has performed marriage of his daughter in the year 2008. In para 29 of cross-examination, this witness deposed as follows: बकाया रकम का जुगाड़ अपने लोगों से जुगाड़ किया था, इसका कोई कागजात नहीं बना. In para 35 of the cross-examination, this witness denied from assertion of the defendant that he has no balance consideration amount. In para 38 of the cross-examination, this witness denied from the assertion of the defendant that there was area of rent against the defendant. On recall of this witness, agreement dated 19/3/2008 has been marked Exhibit 2.
What is the finding of the trial court?
If you notice, we kindly come to page 21.
21. Yes.
So point number 3, Roman 3, at the bottom of the page.
Yes.
Whereas the question of willingness and readiness is concerned, in the present suit in hand, the plaintiffs have not filed or exhibited any cogent evidence in support of their averments that they have offered how many remaining consideration amount on which dates by which lawful means and mode of by check or by demand draft. There is nothing to show that the plaintiffs approached the defendant for payment of rest consideration amount on particular date and time within a stipulated period of 1 year. Moreover, it is settled principle of law, as the Honorable Apex Court has held in case reported in so and so, have pleased to hold that by readiness it may be meant capacity of plaintiff to perform contract which would include financial position to pay purchase price as far as willingness to perform contract is concerned. Conduct of plaintiff has to be properly scrutinized along with attending circumstances. On the case record, there is nothing to show or satisfy this court that the plaintiffs were in a position to pay balance consideration amount of rupees 1,80,000 if any. There was nothing to brought by the plaintiff to show that there was legal source of income of the plaintiff to pay remaining amount on perusal of para 29 of PW 180 Khurshid Alam, who is plaintiff of the present suit, deposed as follows: बकाया रकम का जुगाड़ अपने लोगों से जुगाड़ किया था, इसका कोई कागजात नहीं. So the evidence of plaintiffs to show that plaintiffs have no independent source of income. So it must be ruled that plaintiffs are neither ready nor willing to perform their part of the contract.
So it was never his case that he was arranging that money from his own source.
Yes.
It was a specific case that he was arranging the money from somebody else.
Yes.
So his income tax return or his GST return has got nothing to do.
So that is his evidence was contrary as well. It was without pleading and contrary as well. Now, if I am allowed minors to place the claim, it's a very small 10 paragraphs.
Just. How the learned appellate court has dealt with this finding?
This finding has not been dealt.
They are supposed to deal with the
Yes.
finding, isn't it? The appellate court has given its independent finding without referring to the findings of the learned trial court as to how the appellate court is differing with that finding. These evidences have not been considered by the appellate court. Be sure of it.
Yes, yes. It is not.
Error of record नहीं होना चाहिए
नहीं.
कोर्ट से, बाकी सब चीज ठीक है.
It has not been considered. It would transpire from the findings of the learned first appellate court that the onus has wrongly been put on the defendant. The plaintiff has to stand on his own legs.
Para number.
Same para that I placed on
Yes.
page 38.
These point of determination number 1 and 2 have not been separately considered. सब एक ही flow में consider करें.
Point number 2 has been dealt at page number 14 in regards to point number 2.
You read para number 39. Page number 39.
39.
Internal page 10. Applying the above principles in the present case.
Applying the above principle of law in the present case, I find that PW1 being one of the plaintiffs and full brother of plaintiff number 2 specifically deposed that he had arranged the requisite amount of rupees 1,80,000 just after about 3-4 months of sale agreement. Therefore, the plaintiffs are not expected to exhibit the currency notes as held in Puspa's case to show their readiness and willingness in the ultimate analysis and on the basis of oral evidence of witness examined on behalf of either side and made particularly after careful scrutiny of oral evidence of PW1 who immediately is the plaintiff unknown. I come to the conclusion that plaintiffs were and are capable enough to financially to pay the balance amount of rupees 1,80,000 and they just after 3-4 months of the sale agreement had arranged to manage the given amount which was to be paid in favor of the defendant. And inference may be therefore be drawn outrightly that the plaintiff has succeeded in establishing that they were and are ready and willing to perform their part of sale agreement of handing over remaining amount of cash worth rupees 1,80,000. Accordingly, the point number 1 is decided in favor of the plaintiffs and against the defendant, finding of the court below to the given effect is rejected. This finding is based on minus the paragraph that I read earlier, only upon the oral evidence that GST and income tax returns are being filed.
This is PW1.
There are two things, man. Firstly, this evidence is beyond pleadings, it was not pleaded. Secondly, even if
What was not pleaded? It was not pleaded that they were ready and willing.
they were ready and willing, that has been pleaded.
But further details was
Further
not.
details were not.
What was the source of funds?
Yes.
And how they have arranged, whether there was their own source or whether they were arranging from somebody else. So that was not pleaded. The source of fund was not pleaded.
Yes. Secondly, my lords, if these
Just a minute. Let us see the plate.
Yes.
Yes.
Please the entire.
Just readiness and readiness.
That is paragraph number 9. That the plaintiffs are still ready and willing to purchase the said property and fully described in the schedule of the bill by paying the balance consideration amount of rupees 1,80,000 to the defendant besides incurring expenses for completion of the deal, and the defendant is legally bound to execute registered sale deed in favor of the plaintiffs in terms of the agreement dated 93.
Notice banner 7 and 8.
That the said legal notice was duly served by the defendant, and he got the said notice replied through his advocate Sri Ashish Kumar Sarkar, wherein the defendant admitted the execution of agreement dated 19/3/2008 for sale of his aforesaid property. But the defendant expressed his intention that the defendant does not now want to sell the property. Instead of sale, the defendant shall refund the advance amount of rupees 1 lakh to the plaintiffs very short.
He was ready to take back the money also.
Yes.
Anyways, that is not the question of law.
Agreement balance we are not even discussing.
This is the only above regarding readiness and readiness. Suit was filed when? 2012,
2010.
2010. That is all.
Yes.
Second appeal number 52 of 2022. For the learned counsel appealing on behalf of the appellant, in spite of service of notice and giving opportunity to the respondents to appear in this case, nobody has entered appearance. Any execution case file?
Yes, ma'am. The execution is pending. The details are there in the IAF. Attach the order sheet as well. Execution case number 115 of 2020.
I think the service is properly complete. Personally served. The elder brother, joint is shown. This appeal has been filed. Challenging the judgment dated 5/4/2022, with the bracket decree signed on 16/4/2022, bracket was passed by the learned District Judge Roman 1 Dhanbad in civil appeal number 24 of 2020, whereby the appeal preferred by the plaintiff must have preferred. Who was the appellant before the first appellant?
Plaintiff.
Preferred by the plaintiffs was the appeal preferred by the plaintiffs was allowed. And the judgment dated 23/2/2019, passed by learned civil judge in bracket senior division bracket post number 1 Dhanbad in title suit number 73 of 2010, was set aside. The suit filed by the plaintiff being original suit number 73 of 2010, seeking specific performance of contract of as per agreement dated 19/3/2008 relating to sale of immovable property was dismissed. And the trial court had directed the defendant to return the amount of rupees 1 lakh as received by the defendants to the plaintiff, along with simple interest at the rate of 6% per annum. This appeal was admitted for final hearing by order dated 27/1/2025 on the following substantial issue. The learned counsel for the appellant, while referring to the plaint, has submitted that the averment regarding readiness and willingness has been made in paragraph 9 of the plaint, and has submitted that there is just a mere statement and no further details regarding the source of fund has been mentioned to pay the balance consideration amount. Paragraph 9 of the plaint is quoted as under. The learned counsel further submits that the learned trial court had scrutinized the materials on record and framed the issue regarding readiness and willingness as issue number 7 and decided issue number 5, 6 and 7 and together. The issue number 5, 6 and 7 were as under. The trial court का तीनों issue एक साथ. However, the appeal has been admitted only on the point of readiness and willingness to perform the part of the agreement. He has referred to the trial court judgment and has submitted that the evidence of PW1 has been considered in details and in paragraph 26 of the cross-examination, PW1 in paragraph 26 of the cross-examination, PW1 admitted that he had performed the marriage of his daughter in the year 2008, and in paragraph 29 of his cross-examination, he deposed inverted comma बकाया रकम का जुगाड़ अपने लोगों से जुगाड़ किया था, इसका कोई कागजात नहीं बना था inverted comma. The learned counsel submits that the evidence of PW1 goes to show that he had claimed to have made arrangement for payment of balance consideration from other persons, and no further details was given in his evidence, and he admitted that no document for that purpose was prepared. The learned counsel has submitted that the learned trial court ultimately, after scrutinizing the materials, came to specific finding in paragraph 11 within bracket Roman 3 and held that the evidence of plaintiffs showed that the plaintiffs have no independent source of income, so it must be held that the plaintiffs have the plaintiffs were neither ready nor willing to perform their part of contract. Paragraph 11 within bracket Roman 3 is quoted as The learned counsel thereafter referred to the judgment passed by the learned appellate court and has submitted that the point of determination number 1 as framed in paragraph 13 of the trial court judgment relates to readiness and willingness to perform the agreement, and further refers to paragraph 15 of the appellate court judgment to submit that the evidence of PW1 was considered and reference was made to paragraph 13, 15, 16, 17, 18, 24, 32 and 33 where PW1 was said to have clarified the source of income and the plaintiff was an income tax payee who used to file GST and its returns and was also running BD making business and paying income tax and GST return for that. He has submitted that the appellate court also referred to his further cross-examination that his BD business in the name of Aftab BD was seized and was not functional. And on the basis of the fact that he was filing his income tax return and GST return, the appellate court recorded a finding that there was readiness and willingness to perform the part of contract. He has further submitted that it was upon the appellate court also observed that it was upon the defendant to show that BD making business which was running in the name of Aftab BD was closed earlier. The learned counsel has submitted that the learned appellate court has not at all considered the evidence of PW1 in paragraph 26 where he had specifically stated that he was making the arrangement for money from third parties. Para 26-29. The learned counsel submits that the learned appellate court has ignored the portion of cross-examination of PW1 in paragraph 29 which had a material bearing in the matter. He has also submitted that the averments in the plaint did not disclose as to whether did not disclose the source of arrangement of fund, as to whether he was arranging the fund from his own source or he was arranging the same from third party. The learned counsel has further submitted that the ultimate finding in connection with readiness and willingness is primarily based on the evidence of PW1, and the finding is recorded as under. इसको पैरा 32 से, ठीक है? Yeah. Page number, internal page 10 of the appellate. The learned counsel has submitted that the appellate court has not even met with the reasons and the materials considered by the learned trial court while reversing the finding in connection with readiness and willingness to perform the agreement. He has relied upon the judgments reported in 2022 SCC online SC 840 para 24, 25 and 48 and 46, sorry. Judgment passed by Honorable Supreme Court in special leave petition within that is civil number 13933 of 2021, decided on 28th of November 2024, paragraph 10 to 14. Ten to 12 होगा ना?
Yes.
10 to.
If I'm allowed,
Sorry.
if I'm allowed to say.
Yes.
Lordship, on the point that there can be no evidence beyond the pleading, this non-judgment. 2024 SCC online SC
2024
SCC online SC
online SC
226.
226. Can you provide a copy also?
Yes. Paragraph number 25. There is no quarrel with the proposition of law that no evidence would be led beyond pleadings.
The learned counsel has also relied upon the judgment reported in bracket 2024 bracket close SSC online SC 226 para 25 to submit that the parties cannot be permitted to lead evidence beyond pleading. He has submitted that in absence of any pleading regarding the source of income to perform the part of the agreement to pay the rebalance consideration amount, no evidence could have been led by the plaintiff with regard to the source of fund. Yeah.
Yes.
That is all. He has also relied upon the judgment passed by Honorable Supreme Court reported in 2022 SCC online 71 and has submitted that the principles regarding readiness and willingness has been considered in the said judgment. Okay?
Yes.
Arguments are concluded. Post for judgment on Monday. आप ले लेंगे आज? ये जितने पैराग्राफ्स हैं सब एक जगह करके ले आएंगे, सारा कंप्लीट करके लाएंगे, बाकी पोजीशन सब टाइप करेंगे.
Passover case from supplementary list item 11, second appeal 151 of 2022.
You are the plaintiff, you are the defendant. Defendant. कितने defendants थे?
They are the plaintiff.
Substantial question of law.
Only one defendant. Jaimala Devi. The title suit 35 of 19.
But there are so many appellants.
After her death, their heirs were substituted.
Okay. पहले substantial question of law पढ़िए फिर plaint पढ़ते हैं.
Substantial question of law number 1, whether the lower appellate court was justified in framing additional issue of the adverse position in an appeal filed by the plaintiffs, although the plaintiffs never pleaded any case of adverse position in the plaint. Number 2, whether the lower appellate court, after framing additional issues of adverse position, could decide the case without taking further evidence in connection with the additional issue of adverse position.
If the plaint was not, if in the plaint it was not there, so there is no question of any further evidence also.
Further.
अगर plaint में होगा ही नहीं, तो further evidence का क्या सवाल? Because all the case has to be decided on the basis of pleadings between the parties. Right. Anyways, let us see. Plaint पढ़िए. Plaint पढ़िए.
That the parties are Hindu and governed by the Mitachara school of Hindu law. That both the parties are close relations of each other, their relationship will be evident from the following genealogical table. Dokhal Raut has two daughters, one Sudama Devi, plaintiff, and Darpan Devi. The defendants are the ascendants of Darpan Devi, Ganga Vishnu Raut, and Jaimala Devi. That from the above genealogical table, it is apparent that the Dokhal Rao died leaving behind two daughters, namely Sudama Devi and Darpan Devi. The plaintiff was married to Sardo Raut, son of Lakho Raut, where Darpan Devi was married to Choa Raut. Darpan Devi died leaving behind her only son, namely Ganga Vishnu Raut, who has bought his ancestral house and property situated at Moza, Sonarat. That after the plaintiff Sudama Devi sees the lifetime of her husband, namely Sardo Raut, having purchased 2 katta of Basori land with the house, trees, etc., fully described in the Schedule A from Salma Khatun in the year 1971. Entered in Block 1, Book 1, Volume 2, page number 410 to 414, deed number 2825,
came in actual possession of the same. Both the plaintiffs and her late husband Sargo Rao started living in the said house. So much so that Sargo Rao died in the said house, leaving behind the plaintiff who had been living in the said house as on payment of tax to the municipality and rent to the CO Devgar. That the plaintiff has no other property situated at Devgar for her residential purpose or other purposes, so the suit property is the only property of the plaintiff for her residence. Besides using a portion of said property, the residential purpose, the plaintiff had inducted several tenants in different portions, such as Bhim Rao, Mahendra Rao, Urmila Devi, and others in the said property who have been paying rent to the plaintiff till now. Without any objection from any quarters, the plaintiff has been exercising her right and as owner over the said property without any objection from the side of the defendant or anybody else. That it is admitted fact that the Ganga Vishnu Rao, the sister's son of the plaintiff and the husband of the defendant, namely Srimati Jamala Devi, residents of Moja, Solana, Thari frequently used to visit the plaintiff who lives alone in the suit premises. Not only this, the defendant's husband Ganga Vishnu Rao used to render services to the plaintiff. Even the defendant who used to visit plaintiff's house and helped her in day-to-day affairs. Finding the plaintiff an aged and old lady, there being no male members in her family, brought her in their complete brief in the name of relationship of sister's son and sister's son's wife. That under the above circumstances, Ganga Vishnu Rao defendant got the sale deed executed by the plaintiff in the name of defendant on 3/2/1997. Duly registered in Devgar Sub-Registry Office bearing number 256, serial number 288, which deed is completely illegal, fraudulent, bogus and non-cooperative under the law. As Ganga Vishnu Rao was the close relation of the plaintiff, therefore he used to often visit the plaintiff to help her in the domestic affairs and also in the matter of managing the state of plaintiff. Since the plaintiff is the old lady and often used to have help from her close relation, it is this circumstance the plaintiff was under the domination and dictate of the defendant's husband. As such, the Ganga Vishnu Rao held taking undue advantage of such a relationship, the said Ganga Vishnu Rao surprisingly the fact and making the plaintiff to believe that she was required to be witness in
है एवरमेंट एडवर्स पोजीशन का
There is no such government on adverse position, but I am not having the plant and everything.
तो रिकॉर्ड तो यहाँ पर है यू आर नॉट हैविंग तो इसका हम क्या ही कर सकते हैं
ये लॉट से मैं मतलब पार्ट करके इसको नेक्स्ट वीक कर दिया जाएगा because partly it was allowed, the appeal was partly allowed with regard to schedule B, which is in the possession of the plaintiff.
एडवर्स पोजीशन का आपके यू आर द
Plaintiff defect.
आपके पोजीशन में है पोजीशन आपका
Position.
डिक्लेयर हुआ है
हाँ yes.
पोजीशन तो आपका नहीं डिक्लेयर हुआ है पोजीशन तो इनका डिक्लेयर हुआ है
नहीं कुछ पोजीशन as per their admitted case we came in possession in 99, and since then we are in possession. As per their own case, that is
not the case.
that is the case.
आप लोग रिकॉर्ड नहीं देखते हैं. ऐसा नहीं कर सकते ना हम लोग. नहीं देखे थे तो आपको बोलना चाहिए था ना. ये बस शुरू कर दिया, उसके बाद बोलते हैं हमारे पास प्लेंट नहीं है. पूरा केस ही प्लेंट पर बेस्ड है कि प्लेंट पर कोई एबॉर्मेंट है कि नहीं एडवर्स पोजीशन का.
Plate को पूरा बनाना है.
एडवर्स पोजीशन का एबॉर्मेंट क्या क्या होना चाहिए प्लेंट में? व्हाट आर द बेसिक प्लीडिंग्स फॉर क्लेमिंग एडवर्स पोजीशन? बताइए. Yes, what is the basic pleading for claiming adverse possession?
Milord, this Milord, if you don't see the Tara of the plan, they are saying 7. Page 7 of the plan. Para 3.
इतना काफी है.
3, 4. That the plan.
एडवर्स पोजीशन का प्लीडिंग कहाँ है?
His claim that it was the sale deed was challenged and saying that it was still in possession of the plaintiffs, and they are paying the rent of the municipalities and everything there. That is their.
See, the question of law is very simple. Is there any foundational pleading of adverse possession for the learned appellate court to frame an additional issue of adverse possession? And if there was any pleading, then this issue having been framed, additional evidence होना चाहिए था.
Additional evidence to that point is to be.
Was to be taken. लेकिन additional evidence का प्रश्न तो तभी ना होगा जब foundational pleading होगा plaint में that you are claiming adverse possession. आपका कोई relief भी नहीं है adverse possession का. There is no relief of adverse possession. देखिए डिफेंडेंट जब अपना डिफेंस लेता है तो वो एडवर्स पोजीशन का प्ली लेता है. लेकिन अगर प्लेंटिफ को एडवर्स पोजीशन का प्ली लेना है तो उसको तो डिक्लेरेशन ऑफ परफेक्शन ऑफ टाइटल बाय एडवर्स पोजीशन बोलना पड़ेगा ना. देयर इज नो सच रिलीफ. बताइए, बस इतना ही तो है आपका केस. अगर प्लेंट में नहीं है तो कुछ नहीं है, बात खत्म है. आप तो इतना करते हैं सिविल मैटर्स. बताइए, अगर प्लेंटिफ बोलेगा कि एडवर्स पोजीशन हो गया है तो रिलीफ में रहेगा कि नहीं रहेगा? देयर इज नो रिलीफ. कब से परफेक्शन हुआ, कब से क्या है, कुछ नहीं.
Finding is that from 99 they are in possession.
फाइंडिंग सिर्फ नहीं ना, सिर्फ पोजीशन होने से एडवर्स पोजीशन नहीं हो जाएगा ना. और ये सूट कब फाइल हुआ है? सूट कब फाइल हुआ बताइए? 99. और कब से पोजीशन?
सेल डीड कहते हैं कि 97 में.
वो छोड़ दीजिए, ये प्लेंटिफ कब से पोजीशन में? Since when the plaintiff is in possession of the property?
as per the appellate court judgment, it is said.
Original plaintiff never examined. That is the
इसका
finding.
मतलब नहीं है जो क्वेश्चन ऑफ लॉ बना है बस उतना ही पर
It is discussed in 7.4, the appellate court judgment, para 8.
हाँ पढ़िए
Further, from the appreciation of affidavit and corresponding cross
ये 7.4 दो है
7.4 नीचे वाला.
ऊपर वाला भी पढ़िए
Yes. During the course of argument, this court has made a query to the learned counsel for the respondent as to whether, after disposition, his client came in repossession of the suit property to which there is no satisfactory reply. The counsel verbally submitted that his clients were temporarily dispossessed for a day or two, and thereafter they regained the possession of the suit property. What is evident from WS is that dispossession from suit property by the plaintiff came to the knowledge of defendants on 6/7/2000 or 6/7/2000, and WS was filed exactly 11 days after that, and in the said WS there is mention of dispossession of the defendant. Further,
7.4 पढ़िए इसका कोई रेलेवेंस नहीं 7.4 नीचे वाला पढ़िए
further, from the appreciation of affidavit and corresponding cross-examination, this court could not find out a single instance wherein defendants have averred that they have regained their lost possession of the suit property mentioned in Schedule B. Rather, it is admitted fact that the defendant had lost possession of the suit property on 7/7/2000. What is astonishing to see that neither a separate suit for reclaim the lost possession of the suit property is filed by the defendant, nor any counterclaim or reclaim the lost possession is filed in their WS. This means that the defendant have not claimed their lost possession of the suit property since 7/7/2000. Rather, the information petition was filed in the court in the regard of the same exhibit by then as Exhibit E. Further, as per Article 65 of the Limitation Act 1963, the period of limitation as provided by statute for filing the suit for possession of immovable property or any interest therein based on title is 12 years from the date when possession of the plaintiff becomes adverse to the defendant. Further, from the conjoint reading of Section 3 and read with Section 27 of Limitation Act, the right and remedy both are extinguishing on the expiry of period of limitation as provided by the statute. Since appeal is continuation of the suit, the court, while sitting under appeal, can make additional issues from the material on record in order to adjudicate the matter finally and also to avoid multiplicity of proceedings between the parties. Therefore, this court is making the additional issues and adjudicating it without taking further evidence, as everything is admitted in the record of the trial court. The additional issue is whether the position of the plaintiff become adverse to the defendant despite the fact that defendant have registered sale deed in their favor, and whether such adverse position has not been has made the defendant herein remediless to post plaintiff from the suit property. Further, no evidence is required to adjudicate the additional issue because everything is available on record. Before we proceed, it is pertinent to quote the law laid down in such and such. It has held that there is absolutely no bar for perfection of title by way of adverse possession, whether a person is suing as a plaintiff or being sued as a defendant. The statute does not define adverse possession. It is common law concept, the period for which has been prescribed statutory period, the Law of Limitation Act 65 as 12 years. Law of limitation does not define the concept of adverse possession nor anywhere
contains a provision that plaintiff cannot sue based on adverse possession. It only deals with limitation to sue and extinguishing the of right. Once the right to extinguish another person acquires perspective, right which cannot be defeated by re-entry by the owner or subsequent acknowledgement of his rights. The adverse possession requires all the three classic requirements to coexist at the same time, namely, nec be adequate in continuity, nec claim adequate in publicity, and nec adverse to the competitor in denial of title and his knowledge, visibly notorious and peaceful, so that if the owner does not take care to know notorious fact, knowledge is attributed to him on the basis that due to diligence he would have known it. The old concept of law, the adverse possession can only be used in a seal and not a shore, as be overruled by the Honorable Court in the aforesaid judgment. The appellate court, while sitting under appeal, has unfettered powers under section 107 read with 96 of CPC to appreciate the entire record on law and facts. In the present case, it is admitted fact that defendant that they are not in possession of the suit property since 7/7/2000, and since that day the plaintiff have forcefully possession against the defendant and which is within the knowledge of the defendant. Despite having title documents of the property, no efforts were made by them to evict the trespassers of the plaintiff and reclaim the lost possession. Even it is presumed that the suit is dismissed against the plaintiff and sale deed which is sought to be declared void is held valid and legal, then also it would not make any difference because the defendants have lost their right as well remedy to get evicted the plaintiff and reclaim possession of the property even on basis of title. Merely holding a sale deed would not do anything in their favor, neither any separate suit is filed to reclaim the possession nor any counter claim in the present suit is alleged to reclaim the lost possession. It cannot be said that the defendants were not aware of the illegal adverse possession of the plaintiff. Therefore, the plaintiff's adverse possession ripened against the defendant to avoid multiplicity of proceedings.
क्या है ये मतलब आप ही बताएं मतलब प्लेंटिफ का कोई प्रेयर भी नहीं है कि मेरा पोजेशन एडवर्स डिक्लेयर कर दीजिए आप एक एडवोकेट की तरह सोचिए क्लाइंट की तरह मत सोचिए The Supreme Court has ruled that it can be a sword as well as a shield. ठीक है कोई बात नहीं अब डिफेंडेंट अपना प्ली ले सकता है एडवर्स पोजीशन का पहले यही लॉ था सूट नहीं फाइल हो सकता है फॉर डिक्लेरेशन ऑफ एडवर्स पोजीशन इसमें तो कोई डिक्लेरेशन भी नहीं मांगे है कि एडवर्स पोजीशन डिक्लेयर कर दीजिए इसमें तो खाली यही मांगे है कि डिफेंडेंट का सेल डीड इनऑपरेटिव कर दीजिए ठीक है वो ऑपरेटिव हुआ इनऑपरेटिव हुआ तो आपका तो कोई केस ही नहीं है एडवर्स पोजीशन का कैसे एडवर्स पोजीशन डिक्लेयर हो जाए कोई फाउंडेशनल प्लीडिंग नहीं है कोई प्रेयर नहीं ये तो नहीं हो सकता ना बाकी द सेल डीड हैज बीन हेल्ड टू बी वैलिड
Sale deed has been
उसका तो कोई क्रॉस अपील है नहीं आपका
both the court is finding, but the possession is with.
ठीक है आप रहिए अपना पोजीशन में जब वो रिकवरी ऑफ पोजीशन फाइल करेंगे तब आप एडवर्स पोजीशन का प्ली लीजिएगा आप समझ रहे हैं बात जी इसमें तो एडवर्स पोजीशन का इशू नहीं डिसाइड हुआ ठीक if this court ultimately holds that the court would not have gone into the point of adverse possession because plaintiff did not plead for adverse possession और foundational pleading नहीं तो इसका मतलब ये थोड़ी है कि आपका right to defend the case on adverse possession will be lost क्योंकि इसमें प्रेयर ही नहीं था उस वक्त होता ही नहीं था subsequent judgment आया है ना तो there was no such पहले तो यही लॉ था कि as a sword आप यूज नहीं कर सकते
Let it be partnered. Next, let it be partnered. Any next date.
नेक्स्ट डेट मतलब टुमारो इतना सुन
Not
लिए
tomorrow नहीं.
अभी लिखाते हैं
tomorrow.
अभी अभी लिखा
I am
नहीं नहीं
not tomorrow.
नहीं ऐसा नहीं हो सकता।
Only.
नहीं इतना
थोड़ा सा हम भी और एग्जामिन कर लें।
क्या एग्जामिन करना है, कोई डॉक्यूमेंट का जरूरत नहीं, सारा रिकॉर्ड है। नेक्स्ट वीक नहीं होगा, हम तो अभी लिखाने वाले हैं, आपको दे दे रहे, सेकेंड हाफ में आ जाइए।
सेकेंड हाफ मेरे पास नहीं है, आई एम नॉट इन पोजीशन ऑफ ऑल द डॉक्यूमेंट्स। आई आफ्टर
है तो यहाँ
नहीं
सारा
नोटिस हुआ था इनको लिमिटेशन पर, उस पर हम अपीयर किए थे। आई वाज नॉट, दैट इज ऑन द पॉइंट ऑफ लिमिटेशन। नोटिस हुआ था
नहीं, हम देखिए हम सुन लिए हैं, प्लेन पढ़ लिए हैं, अब आपको जो लॉक लाना है आप कल लेकर आ जाइए। नहीं ऐसा नहीं हो सकता। Second appeal number 151 of 2020. For the learned counsel appearing on behalf of the appellants, the learned counsel for the appellant has placed the entire plaint and has submitted that the foundational pleading in connection with adverse possession, neither there is foundational pleading in connection with declaration of adverse possession of the plaintiff, nor there was any relief prayed by the plaintiff seeking adverse possession, and therefore the appellate court has completely misdirected itself while framing an issue in connection with adverse possession of the plaintiff and deciding the same in favor of the plaintiff.
only with regard to part of the schedule.
The learned counsel submits that the adverse possession has been declared only in connection with Schedule B property. She has submitted that so far as the declaration relief prayed for in the plaint is concerned, with regard to declaring the sale deed dated 3/2/1997 as invalid, the same has already been decided in favor of the defendant, and such plea has been rejected. The learned counsel has also placed the appellate court judgment in order to respond to the arguments advanced by the learned counsel for the appellant. The matter is adjourned at the request of the respondent to be taken up.
To be taken up.
10:30 बजे आ जाइए, आप कर देंगे,
कल?
थोड़ा ही समय, रिकॉर्ड यहीं है, पढ़ लीजिए। 5 बजे तक यहीं रहेगा, बोलिएगा तो 6 बजे तक नहीं देंगे। एकदम बहुत सिंपल सा मैटर है, फाउंडेशनल प्लीडिंग होता है, कब से एडवर्स हुआ इसका स्पेसिफिक डेट देना
Yeah, the
पड़ता है।
specific date is there. That
अरे
is-
फाइंडिंग है,
Yes.
प्लेंट में नहीं है।
Plaint, no. The case is that even after filing of the, as per WS file in 2000, they have admitted my position.
Mere
And they have,
admission.
and they have admitted, and they have not filed any suit for my eviction.
नहीं किए,
Yes.
नहीं किए।
हाँ. Therefore, my lord.
आपका सेल डीड को बोलते हैं फोर्स्ड है।
हाँ, ठीक है।
आपने बोला है फोर्स्ड, वो उन्होंने आपके इविक्शन के लिए नहीं फाइल किया है, दैट इज देयर प्रेरोगेटिव। चूंकि उन्होंने आपके इविक्शन के लिए नहीं फाइल किया है, इसलिए आपका एडवर्स पोजीशन डिक्लेयर हो जाना चाहिए, ऐसा कोई लॉ हो तो बताइए। ठीक है, ऐसा कोई लॉ नहीं चाहिए। हफ्ते सुबह 10:30 बजे एज फर्स्ट केस। पाठ कर देंगे इसको।
From daily list for orders verified item 6, second appeal 476 of 2018.
Paying for a short possible money.
पास ओवर किस लिए चाहिए?
Lord senior counsel is another court member.
अरे ऑर्डर्स में ये केस है, वो भी डिफेक्ट।
Well, three cases may be possible.
देखिए, ऐसे नंबर 476 of 2018. Counsel for the appellant is present. As per the office note, only judgment with authentication. Has been filed.
Lordship, there are 3 defects that have been removed by filing supplementary DTC. Defect has been already removed.
Supplement डिग्री का है?
हाँ?
डिग्री?
हाँ, डिग्री फाइल कर दिया है, लोअर कोर्ट का डिग्री मांगा गया था, that has been filed.
तो सप्लीमेंट्री एफिडेविट में आप क्या लिखे हैं कि डिग्री नहीं बना है?
नो, वो अपीलेट कोर्ट का, उस पर डिफेक्ट नहीं है, डिफेक्ट है ओरिजिनल कोर्ट का.
जरा इनको बुलाइए, आप पता करिए इसमें क्या डिफेक्ट है. इसमें इन्होंने ये डिफेक्ट लगाया है कि ओनली जजमेंट विद ऑथेंटिकेशन फी हैज बीन फाइल्ड.
हाँ, तो वो फाइल कर दिए.
Judgment. A supplementary affidavit on behalf of the appellant in which stated that decree has not been passed by the appellate.
हाँ, वो अपीलेट कोर्ट का, उसमें उसका डिफेक्ट अलग है. उसका डिफेक्ट है कि डेट दीजिए, उसमें डिग्री नहीं माना गया है. ये डिफेक्ट नंबर 1 देखा जाए, उसमें केवल डेट मांग रहा है हमसे. तो चूंकि डिग्री अभी पास नहीं हुआ, इसलिए हम सप्लीमेंट्री में लिखे कि सिंस डिग्री हैज नॉट बीन passed, therefore it is not possible to supply the date regarding appellate judgment.
तो इसका मतलब आप यही लिखे ना कि appellate कोर्ट का डिग्री नहीं पास हुआ.
हाँ.
तो ऐसा तो नहीं ना बोलिए कि डिफेक्ट रिमूव हो गया ऐसा.
नहीं, जो डिग्री का डिफेक्ट है एक योर है, वो डिफेक्ट नंबर 4 है.
वो तो सर्वाइविंग डिफेक्ट है ही नहीं, लेकिन डिफेक्ट आप ऐसा तो नहीं बोल सकते ना कि डिफेक्ट रिमूव हो गया है.
हाँ, सप्लीमेंट्री में एक्सप्लेनेशन दिए हैं. That में
दोनों में फर्क है कि एक ही बात है दोनों में.
I have given explanation in supplementary affidavit.
इसलिए ऐसा मत हमसे बुलवाइए कि डिफेक्ट सब रिमूव हो गए. नहीं हुए. देखिए सेकेंड अपील नंबर 476 of 2018. The learned counsel for the appellant has submitted that a supplementary affidavit has been filed in the present case stating that the appellate decree has not been prepared. Office is directed to call for a report from the concerned court as to whether appellate decree has been prepared, and if so prepared, a copy of the same be forwarded.
उसमें एक भी लगाया नोट से रिकॉर्ड ऑफ द लोअर कोर्ट वेबसाइट का, जिसमें बता रहा है
वेबसाइट में कुछ एरर भी हो. Post this case on 26th March, awaiting the report.
Item 7, second appeal 201 of 2023.
2 week time for the
Essay number 201 of 2023. Counsel for the appellant prays for and is granted time till 18th of March 25 to remove the surviving defects. छोटा छोटा डिफेक्ट है, कर देंगे, प्रेमट्री कर देंगे.
Yes, ma'am.
Preemptory. If the defects are removed within time, post this case under appropriate heading on 20th of March.
Item 8, first appeal 260 of 2023.
Both serial number 89 limitation petition as well as court fees. Since the court fees is a bit steep, in first case it is 21,000 and second case it is 60,000 something. The petitioners need some time to arrange the money to the members because they are not in a very good financial condition. So I'm praying for 4 weeks time.
FA number 260 of 2023. Time till 26th March is granted to the appellant to remove the surviving defects preemptory. If the defects are removed within time, post this case on 27th. Same order दोनों में कर. 26th तक टाइम दे रहे हैं ना आपको, 28th को. एक दिन छोड़ under appropriate heading.
Item 10, second appeal 267 of 2023.
May your Lordship, for 3 weeks and the defects, the further strand reporting has been done, Your Lordship.
Time till 26th March is granted to the appellant to remove the surviving defects. Preemptory. If the defects are removed within time, close this case on 28th of March. ऑफिस में जाके देख लेंगे बहुत सारे डिफेक्ट्स हैं छोटे-छोटे. आपके सीनियर कौन है?
ओंकारनाथ तिवारी.
आप ऐसा करिए, डिफेक्ट नोट किए हैं?
Yes.
सारे डिफेक्ट्स नोट कर लिए हैं?
Yes. Okay.
प्रेम्प्टी ऑर्डर के साथ बहुत दिक्कत है. ऑफिस में जाके अपना टाइमली देख लेना चाहिए. ऑफिस में भी बोलिएगा ना, कोई एडवोकेट आए क्योंकि प्रेम्प्टी ऑर्डर है, कुछ बाकी है डिफेक्ट, तो दे शुड कोऑपरेट. दिखाते हैं ना.
Item 11, first appeal 43 of 2024.
ये भी डिफेक्टिव है.
Yes.
सेम ऑर्डर कर देंगे. Nobody appeals for the appellant. However, time till 26 March is granted to the appellant to remove the surviving defects preemptively. If the defects are removed within time, post this case on 28th of March under appropriate heading. Let a soft copy of this order be forwarded to the learned counsel for the appellant, Mr. Rajiv Nandan Prasad.
Item 12, first appeal 136 of 2024.
Defective.
Case lordship will find an IA. Lordship will remember the same case lordship when the party was not substituted in the trial court.
Yes, yes.
The decree was passed. Lordship.
You are for the respondent?
Yes, 327. I have filed a journal also by way of flag by.
अच्छा, आपने reply फाइल कर दी?
जी.
तैयार?
समय लगेगा उसको. Monday. I am ready. Though I am ready, lordship. Some judgments are to be referred, lordship.
हाँ तो कहाँ?
हाँ ठीक.
Judgment कहाँ है?
हाँ right.
आप तैयार हैं ना?
इसमें अगर आइए तो अलाउ कर दिया जाए तो सब्स्टिट्यूशन सुप्रीम कोर्ट का एक जजमेंट मेरे पास भी है.
हाँ दिखाइए.
और
This is one judgment passed by the Honorable Court, lordship. Content bench.
Statutory कहते हैं right to survive. There is no abatement. No abatement by parties. There is right to sue survive. Order 22 का हो. Although my objection is there. And Supreme Court has also ruled in favor of the other.
दोनों सेम जजमेंट दे रहे हैं. दोनों अलग-अलग जजमेंट.
सब अलग है.
नहीं, आप भी तो कोई जजमेंट दे रहे हैं.
नहीं, उसमें हम दे रहे हैं कि अलाउ हुआ इडी के पक्ष में.
हाँ ठीक है, बता ही दीजिए ना कौन सा जजमेंट.
हम तुरंत बतलाते हैं.
हमको बता दो.
जी जी.
हो सकता है कि उसी में से हो.
ये रिसेंटली 17 फरवरी को जो हुआ है सुप्रीम कोर्ट से.
अच्छा ये वाला. ये वाला है. ओम प्रकाश गुप्ता वाला.
हाँ सतीश चंद्र यही 340 इसके बारे में.
I am prepared on that.
हाँ स्पेसिफिक पर्पस
ज़्यादा बेटर हो जाए. लेंथी है ये थोड़ा.
स्पेसिफिक पर्पस और कॉन्ट्रैक्ट में जो ये रिसेंटली दिस मंथ.
कौन सा पैराग्राफ आप इसमें पैराग्राफ बताइए. स्पेसिफिक परफॉर्मेंस ऑफ कॉन्ट्रैक्ट से जरा बताइए, इसका फैक्ट बताइए, तब ना ऑर्डर करेंगे.
थोड़ा सा देख लेते हैं.
आइए नंबर.
इसी को हमने लिखे.
आइए नंबर बताइए.
आइए नंबर लॉर्डशिप 236.
हाँ जरा बताइए आइए में क्या लिखा.
From paragraph 4, Lordship.
पढ़ी ये पहले 1 भी पढ़ी
Paragraph 1. Lordship, one of the plaintiff, namely this Sankar Mahto Lordship, had died during the pendency of the suit, Lordship, on 23/5/2023. And thereafter, Lordship, the defect has been pointed out by the stamp reporter that he has not been made party. Original plaintiff number 4.
ठीक
We did not make him made him party not because since he had died, Lordship. And for ignoring said defect, Lordship,
and he was not substituted.
not substituted. Either any application was also not filed in the trial. Thereafter, Lordship, we have given paragraph 5 onwards, Lordship.
इन लोगों को आपने पार्टी बनाया
हाँ, अभी इनको रीता महतो और मोनिका महतो को बनाना है एट पैराग्राफ 5.
वकालतनामा आ गया
नहीं, हम नहीं बना रहे, हम इनको परफॉर्मा रिस्पोंडेंट इम्प्लीड करने की बात कर रहे हैं, सिंस वी आर नॉट गेटिंग द वकालतनामा.
they be implemented as pro forma
Yes, that is my claim.
and you are the
We are the plaintiff appellant. They were also the plaintiff. Their father was the plaintiff. Now, since they are not giving wakalatnama to us, therefore they have to be imputed as performance.
that's it अब judgment बताइए
One by one. Lordship is having question.
अगर एक जजमेंट काफी है तो एक ही
हाँ, एक उसमें हमारा जो हाई कोर्ट का एक हुआ है कोऑर्डिनेट बेंच का, उसमें 2-3 जजमेंट ये कंसीडर हुआ है, except this recent one judgment, Lordship. In that judgment, Lordship, although it was the matter was remanded back.
इसीलिए ऐसा नहीं करिए ना, सीधे सुप्रीम कोर्ट का जजमेंट.
हाँ, ठीक है. Then Lordship will kindly come to 2016 volume 1.
हाँ.
Paragraph 11, Lordship, the direction given. Last paragraph.
11.
In the result, the impugned order is set aside, the appeal is allowed, and following directions are issued. Necessary applications were filed to bring on record the legal representatives of appellate number such and such are allowed, and legal representatives of appellate to Swaraj are ordered to be brought on record. It is by the Honorable Supreme Court, Lordship, at that stage. Now, CMP number such and such, Manju are ordered to be brought on record and the application is allowed. RSA number such and such on the file of High Court is ordered to be restored. The memorandum of second appeal is suitably amended. An amended memo of appeal shall be filed before the High Court within 4 weeks. The High Court shall afford an opportunity to the hearing of the parties and shall dispose of the second appeal in accordance with law as expeditiously as possible. On this direction, Lordship, the Honorable Coordinate Bench, Lordship, had remanded the matter back in that case also. That was also not done in that case, and therefore the matter was remanded. But in some cases, Lordship, the Honorable High Court, the Honorable Supreme Court has stated that why not after substituting the High Court, why not the High Court himself had heard the matter?
Because if the matter is remanded, they may have an opportunity to
Yes.
give evidence.
Yes.
Therefore, the matter has to be remanded.
Yes. 2005 SSC, Lordship. Paragraph 9. Perhaps I have marked the portion, Lordship. Last page.
Yes.
From where I have marked, Lordship.
Yes.
Now the legal representatives that I have marked, Lordship.
ये पूरा पढ़िए.
The situation, we think that the interest of justice would subserve that if the orders of the degrees passed in the suit, in appeals and in the second appeal are set aside, and the suit remanded to the trial court for making proper inquiry into the question, it is on the basis of compromise, but the issue is same. Compromise of the dispute between the Bihari and one on the one hand, Ishun and Ramchandra on the other hand, and the record of finding thereon, the terms of the coercion order 23 Rule 3 of the court. Now, the legal representatives are before us. The trial court will direct the formal correction of the cause title in the plaint, giving an opportunity to the supplemental plaintiff to bring on record other legal representatives of the parties to the suit, if any. The trial court will thereafter proceed to decide the question of the existence of or otherwise of a compromise or an adjustment of the dispute. If it comes to the conclusion that there was a compromise of the dispute, it will consider whether the compromise is lawful and could be accepted by the court. In the case it was found lawful, the degree sentence.
So ultimately, what do you want? It has to be remanded back.
That will be a better preparation, Lordship, since the legal heirs have also not given Vakaratnama to us. Had it been the plaintiff inter se would not have been any dispute, then I could have said Lordship can hear the matter. But since they are not in a very good situation with us, they have not given the Vakaratnama, and therefore they are likely to be added as performer respondent.
And if
They may contest, they may support.
They may come And
Yes.
then they will decide whether it has to be remanded or
Yes.
not remanded.
That can also be done.
Because they may say
After
that,
notice,
that
yes.
they don't want to contest.
Yes.
They
Then
may
the
say
matter
that
can
they
be-
don't want to contest.
After substitution, the matter can be decided here also.
In this case, the present respondent who is for substitution, her sister who is the respondent number, plaintiff number 4A and 4B has been substituted, and present disease is the brother of the both the sister. So having the knowing well when her brother has died.
That is
and
true.
also
That I have said.
Limitation has not been filed under section 120 and 121 of the limitation application.
In all those
In
cases
the
which
present
you
application, the same substitution was filed in absence of limitation application as per the 120 90 days and 121 60 days.
You see, in a case where the plaintiff expires, in a case where the defendant expires, it is for the plaintiff to take
No, it is my
step.
duty, Lordship. In this case also plaintiff has expired.
Plaintiff
It was my
expired.
duty. It was not done there, Lordship.
वाहन
In
को
other
खराब
cases
है,
also,
भाई का
Lordship,
death हुआ है,
it has
family members
already
से-
been considered that
उसके
it
बाद
is
वो
a
substitute नहीं कर
fallacy
रहे
on the part of the plaintiff, but it was also the duty. Had they been very cautious, it was also their duty of the respondents also to file an application at 10A. That was also not filed, Lordship. Admitting everything, the best position will be that, Lordship, let them be noticed. If they come here, if they
On
want to
this
support the
interlocutory
plaintiff,
application, on this interlocutory application, we will notice them.
that can also be done. And thereafter it can be substituted. And Lordship may decide thereafter whether the Lordship will be hearing this matter or the matter will be remanded. Only that is the question to be decided.
तो इनका कहना है आपने कोई लिमिटेशन वगैरह भी नहीं
नहीं नहीं हुजूर, इसमें चूंकि जो judgment which I have 2016 judgment, the same situation was there. The application there was only on 110. We have filed an application 22(3) also, but since limitation has not been filed knowingly, Lordship, because it is not an original suit. It is an appellate provision, and we are only seeking the mercy of this honorable court by citing various judgments. And in all the judgments, Lordship, the 110 petition was filed, and that was allowed, treating the same to be under 22(3), and limitation was not required to be filed. Since it is vivacity of the justice has to be done, the point has to be decided on merit.
IA number 236 of 2025.
See something. ये जो जस्ट अभी रिसेंट जजमेंट है 1340 वाला उसके पैरा 11 में जो दिया हुआ है कि लिमिटेशन एप्लीकेशन फाइल करना है स्टार्ट फ्रॉम 91 डेज
आप एक लिमिटेशन कर भी दीजिए ना, तो
हाँ,
क्या
कर-
फर्क? कर दीजिए,
हाँ,
फिर उसके साथ ही
हाँ,
कर देंगे,
Yes.
है ना?
जी
Learned counsel for the appellant are present. The counsel for the respondents has submitted that no limitation petition has been filed in connection with the interlocutory application, in connection with the relief seeking through interlocutory application. Counsel for the appellant prays for some time. Pose this case on, बताइए कब रखते हैं?
12th को रख दिया 12 6 या 11 को रख
On 11th,
Lordship.
in the supplementary cause list.